Chief Justice, members of the court, or rather Deputy Chief Justice and members of the court, together with my pupil Tembelihle Links, we appear on behalf of the applicants.
Thank you, Mr. Ramkhale.
Deputy Chief Justice, members of the court, I appear on behalf of the respondents together with my pupil Khadija Bawa.
Thank you, Mr. Simmons. Ramkhale.
Deputy Chief Justice and Justices of the court, this appeal concerns a single question of law: whether the Department of Home Affairs can be compelled by a mandamus to receive and determine a fresh asylum application from a person whose previous application has been finally rejected under the Refugees Act. The respondents say yes, that the principle of non-refoulement and the international law confer on them a continuing entitlement to reapply whenever circumstances in their home country change. The department says no, that once a statutory process has been lawfully completed, there is no further duty in law to accept a second application, and that the protection of non-refoulement does not create a perpetual right to restart the process. As this court has said in Pharmaceutical Manufacturers Association, public power is only legitimate when sourced in law. Therefore, this case is about legality, whether a clear right exists that the court can enforce through a mandamus. The answer we submit is no. No such right exists, not in statute, not in international law, and not in comparative jurisprudence. Our submissions in outline are these. First, as to the nature of the claim, this is not a constitutional challenge to the Refugees Act. The respondent accepts the statute's validity, but they seek to add to it. But a mandamus cannot create a duty that Parliament has not imposed. It can only enforce one that already exists, because the Act contains no provision requiring the department to accept a repeat application. The claim fails at the first hurdle. Second, we will submit that the respondents conflate two very different ideas: that surplus refugees and that of a repeat applicant. A refugee surplus is a person who was not a refugee when they left their home country, but became one later as a result of new events. The respondents are no such persons. They left expressly to seek asylum and have already had their adjudications, or rather their claims, adjudicated. They are re-applicants seeking to reopen what the statute has closed. Third, we will submit that the principle of non-refoulement, as central as it is, does not assist them. It is not absolute, and it has never been treated as such, not in the Refugee Convention, not in South African law, and not by this court. As Ruta, Abor, and more recently Ashebo confirm, non-refoulement is a shield during the process, not a sword to be used afterwards. It prevents unlawful removal while a claim is still being determined, but it does not create an indefinite right to remain or to reapply once finality has been reached. Fourth, there is simply no right to reapply in the Act. Sections 21 to 24 of the Refugees Act established a single linear process that ends in finality under Section 25(4). Once a claim has been rejected, the Act says that the person must be dealt with under the Immigration Act. That is where the Refugee Act ends, and Parliament has not created a second tier. Other jurisdictions have done so expressly through fresh claim procedures. Ours has not, and this court cannot legislate one into being. Fifth, the respondent's reliance on the definition of abusive application is misplaced. That definition exists precisely because Parliament foresaw that some people might attempt to repeat filings. It empowers officials to reject such conduct, not to entertain it. To locate a right in the very clause that defines its abuse is to invert the statute's logic. The abusive application provision is a shield against repetition, not a gateway to it. Sixth and finally, the invitation that the respondents extend is that the court cannot accept the invitation that the respondent extend is one the court cannot accept without crossing the line that separates interpretation from legislation. The creation of a new procedural mechanism, when, how, and by whom further applications may be lodged, is a matter of lawmaking. Those are questions for Parliament, not the judiciary. As this court has said in my vote counts and other judgments, where the legislature has been enacted to give effect to a right, it is for a litigant to assert the right in the legislation itself as it is, or to challenge the constitutionality of the act as insufficiently protecting that right. In the end, the case reduces to this. A mandamus can compel what the law requires, but it cannot conjure what the statute does not provide. The Refugee Act establishes a fair and finite process that balances compassion with finality. To reopen it indefinitely would erode that balance, collapse finality, and undermine the rule of law itself. The department therefore asks that leave to appeal be granted, that the appeal be upheld, and the order of the Supreme Court of Appeal be set aside, and that the order of the High Court dismissing the application be reinstated. With those opening remarks, I will begin with the first submission we make, which is about the nature of the claim that the court is dealing with. The respondent's case is styled as an application to compel the Department of Home Affairs to accept and determine a further asylum application after the previous claims were finally determined under the Refugees Act. If the court could turn to the core bundle, that would be the first core bundle, on page CB2. This is the notice of motion that was filed in the High Court. And in prayer 1, the respondents ask that the first and second respondents, being the applicants in this application, are directed to accept the asylum seekers' application of applicants in terms of sections 21 of the Refugees Act, based on the applicant's surplus refugee claims within 5 working days of granting of this order. So that is the relief that they had sought before the High Court. Not a review, not a constitutional challenge. Then if the court turns in the same bundle to CB9, which sets out the claim, and I'm reading now from paragraph 12, which is at the foot of the page. It reads that all the applicants are asylum seekers from Burundi who have previously applied for asylum in South Africa. Each of the applicants' application, I'm reading now on the next page, were rejected as manifestly unfounded in terms of section 24.3 of the Refugees Act, the final rejections. But subsequent to the filing, circumstances in Burundi have changed for the worse. The details of the recent widespread political violence in Burundi are set out below, but the results thereof are that the applicants are not in a position to return safely in Burundi, notwithstanding the decisions against them. As a result, the applicants are known as what is called surplus refugees, persons who may not have been refugees when they left their countries of origin, but who become refugees at a later date due to change of circumstances in their home country. And then important, at CB 12, at paragraph 26 in the same bundle, at the foot of the page, the founding affidavit says, this application does not seek to review or set aside the final rejections of the applicant's previous asylum seeker applications. Then on the next page, instead, in paragraph 27, it seeks to permit the applicants to submit fresh asylum seeker applications as surplus refugees in light of the change of circumstances in Burundi since their final rejections. So what becomes clear from the notice of motion together with the founding affidavit is that the applicants accept that their applications were in fact rejected. What they seek to assert is a mandamus, and in order to get there, they need to demonstrate that they have a clear right to reapply. And the court will also find, further on in the founding affidavit, that the applicants, or rather respondents in this court, readily accept that they may have been lawfully rejected on the basis of the application that they had initially sought. I will find that reference and point the court to it. So what we say is that despite the language used in their affidavits, this is not a constitutional challenge, nor is it a review of administrative action. It is a mandamus, a request for the court to compel performance of an existing right. And that distinction is crucial because the mandamus cannot create new obligations. It can only reinforce duties that already exist. Therefore, the respondents must demonstrate a clear legal right and a corresponding legal duty owed by the department to accept fresh asylum application. If that duty does not exist in law, the case falls at the first step. I don't need to tell the court about the test for a mandamus. It's set out in the trite Sitlogelo versus Sitlogelo decision of the appellate division. With that then said, Deputy Chief Justice, if I could move on then to the second point, which is about the distinction between a surplus refugee application and a repeat applicant. A central confusion in the respondent's case lies in their conflation of the two entirely distinct concepts under refugee law. That is a refugee surplus and a reapplication. They attempt to justify their second application by invoking the surplus principle, arguing that changed circumstances in their home countries entitle them to a new asylum claim. But on their own version, they left their countries as asylum seekers. They were not ordinary travelers whose situation changed after departure. That distinction is critical, and it is foundational to the application. The term refugee surplus originates in paragraphs 94 and 95 of the UNHRC Handbook on Procedures and Criteria for Determining Refugee Status. It is not included in full text in the record, but it appears in the judgment of the SCA. The court will find that in volume 5, at page 478. At paragraph 15 of the SCA's judgment, the court writes that the concept of refugee surplus is expressly recognized by the UNHRC, the body responsible for overseeing the implementation of the UN Convention. In its Handbook on Procedure and Criteria for Determining Refugee Status, it explains the concepts and gives guidelines for determining whether a person is a refugee surplus. It provides, and this is the most crucial part, a person who was not a refugee when he left his country, but who becomes a refugee later, at a later date rather, is called a refugee surplus. So in other words, when you left your home country, to use the example in the respondents' heads of submissions, and you are a Palestinian on the 7th of October 2023, and calamity arises in your home country on the 8th, the 9th, the 10th of October 2023, not leaving Palestine with the intention of seeking refugee, but for whatever reasons there might be. But as a result of those events, you now need protection of a foreign country. That's very different to the respondents. They expressly say that they left their home countries fleeing persecution. That's why that particular distinction is important. So in other words, the defining feature of a surplus claim is a change of circumstance arising after departure from your home country, where the individual could not have sought asylum because the risk of persecution did not yet exist at the time that they left. And no party squabbles with this particular definition. It seems we are at idem that that's the definition of a surplus refugee. And this much is clear from the respondents' founding affidavit, which I indicated the court to, but also in their heads of argument, where they seem to accept that the definition is as is, but they say it's an interpretive aid to understand what a surplus refugee is. So, by contrast, the respondents in this case left their countries expressly seeking asylum. Their first applications were considered, rejected, and finally determined under Section 24(5) of the Refugees Act. They are therefore not surplus refugees. They are repeat applicants, individuals seeking to reopen a process that has already run its course. Their argument that changed circumstances justify a new application confuses substantive change in the refugee status with a reapplication. The former is what surplus refugee addresses, The latter is precisely what the Act forecloses through its structure and its definition of abusive applications. And if Parliament intended to create a second procedural tier for post-finality events, it would have expressly said so. As did the UK, as did New Zealand, as did Canada, all the examples that the Supreme Court of Appeal relied on in its analysis of foreign case law. But all of those countries have expressed legislative provisions. Our Act, however, is silent, and on our submission, that silence is deliberate. The UNHRC handbook, the EU Qualification Directive, and the comparative jurisprudence from the UK, Canada, all treat surplus status as a substantive question of refugee characterization, not a procedural right to reapply. Because a surplus refugee left their home country not seeking the protection of a foreign country. Very different to a reapplication. And South African law is quite consistent with that distinction. In Ruta, this court in paragraph 54 spoke of non-refoulement protecting those whose claims are being determined, and that the shield falls away once that has been achieved. Similarly, in Abor, this court recognized that protection applies within the determination process, but once that comes to an end, the shield of non-refoulement falls away. Neither of those decisions suggests that a process whose claim has finally been determined can demand that the process begin afresh. So we say that the respondent's approach would erase the distinction between a person who becomes a refugee because of new events, a surplus refugee, and those who simply want a reapplication of a failed asylum application. That construction on our submission undermines the purpose of the Act, which is to provide a fair but a finite process for determining refugee status that ultimately ends in finality in terms of Section 24(5). And if the respondent's conflation were to be accepted, the refugee system would be indeterminate, there would be no end to the process. Administrative capacity would be consumed by repetitive claims, diluting protection for genuine surplus cases that truly arise after departure. And it would effectively transform the temporary shield of non-refoulement into a permanent right of residence, contrary to Ruta, contrary to Abor, contrary recently to Ashebo, and the structure of the Act. Deputy Chief Justice, members of the court, if I could now then move on to non-refoulement, given its importance in this case. The respondent's principal premise is that the department is under a continuing duty, grounded in non-refoulement, to receive and consider a further asylum application even after their first application has been finally rejected. The court will find in their heads of argument at paragraph 46 that they say, we accept non-refoulement, we accept this decision in Ruta, we accept the decision in Abor, but non-refoulement continues to apply even after an application has been finally rejected. That simply does not square up with the jurisprudence of this court, and certainly not the finding of the Supreme Court of Appeal. They suggest that because non-refoulement protects individuals from return to potential prosecution, it necessarily implies a right to reapply whenever circumstances change. That premise is fundamentally flawed. Non-refoulement is a rule of protection, not of perpetual procedure. It is a shield against removal while the process unfolds, not a license to relitigate after the process has ended. Neither international law, nor South African jurisprudence, nor the Refugee Act itself recognizes it as absolute or perpetual. And this particular argument was rejected by the SCA. If the court could turn to volume 5. At page 499. These very same arguments that we've been contended for by the respondents in the SCA, this is what the SCA has to say about that. It says, it is convenient to clarify the reach of the principle of non-refoulement. When it is said that the principle is absolute, it means this: the protection afforded by principle endures for as long as an asylum seeker has not exhausted all available remedies, internal appeals, and judicial review. But once these processes are exhausted, an asylum application is finally rejected and the protection falls away. 4, it is implicit in that rejection that the claim does not meet the definition of a refugee. In other words, they do not have a well-founded fear of persecution for a convention reason as envisaged in Article 1A1 of the UN Convention. Paragraph 72, under those circumstances, requiring them to return to the country from which they fled would not violate customary international law. As explained by this court in Ruta, until the right to seek asylum is afforded and a proper determination procedure is determined and completed, the Constitution requires that the principle of non-refoulement, as articulated in Section 2 of the Refugees Act, must prevail. The shield of non-refoulement may only be lifted after a proper determination has been completed. And I've already taken the court through the founding affidavit and what it says about the first determination. Also, as correctly observed by this court in Somali Association versus Refugee Appeal Board, there is a legitimate state interest and concern to ensure that the refugee status is granted only to those who qualify, to disqualify unfounded applications, and to provide for the cessation of refugee status. The construction of the principle favored by the appellant in Scalabrini is at odds with the above dicta. If their construction were correct, there would never be an end to a cycle of asylum applications. I do not think that the principle goes as far as to suggest that once an asylum seeker makes an application, he or she will never be returned to their country of origin, irrespective of an outcome of such an application or its final determination. And we respectfully submit that the SCA is correct. So, within the scheme of the Refugee Act, non-refoulement operates as an internal safeguard, ensuring individuals are not removed before their claims have been lawfully adjudicated. It protects the integrity of the asylum process, not endless repetition. Once this process has reached its statutory conclusion, when an application has been finally determined under Section 24(5), Parliament directs that the person must thereafter be dealt with in terms of the Immigration Act. At that point, the protection shifts from refugee to immigration law, consistent with both domestic and international frameworks. To construe non-refoulement as authorizing perpetual reapplications would invert the design, effectively nullifying Section 24(5) and turning a temporary safeguard into an unending entitlement. So non-refoulement is not absolute, not in our law, and certainly, as the court knows, there is no such thing as a right that has no limitation. And Section 24(5) is therefore drafted in the language of closure. It represents Parliament's decision to balance protection with finality. Once an asylum claim has been finally determined, the applicant falls within the immigration regime. To imply a continuing right to reapply in the name of non-refoulement would undo that finality, contradicting both the text and the structure of the Act and the rule of law value that demands closure. With that then said, Deputy Chief Justice, the fourth point we make is that there is no clear right anywhere in the Act. To succeed in the mandamus, the respondents must demonstrate a clear legal right and a corresponding legal duty on the department to perform the act sought to be compelled. They have identified no such right. Their case depends on three supposed sources. The first is the principle of non-refoulement, but the difficulty they have there is that non-refoulement is not absolute and it is subject to finality. Foreign jurisprudence, and I will deal with the foreign case law as my fifth point, and the Refugee Act itself, particularly the definition of abusive application. Their argument is, well, the Act in defining abusive application contemplates that there might be more applications and therefore your reading of the Act is incorrect. Each fails on its own terms. None establishes a positive, enforceable duty to accept and process repeat asylum applications after final determination. I've already made submissions about how non-refoulement operates. It is a shield during the process, not an entitlement to reapply. I've also made my submissions about the distinction between a surplus refugee and a reapplication, being that a surplus refugee is a person who leaves their country not seeking refugee status or asylum, but as a result of intervening act needs to do so. Very different to a reapplicant who has gone through the process, has been adjudicated, and the application has been finally determined. To succeed, the respondents must demonstrate that there's a right to reapply, not that they are surplus refugees. In our submissions, we set out the 4 stages that an asylum process follows. The court will find that in our heads of argument, in which we set out the process from section 21 down to section 24. And again, we submit that if Parliament had intended to confer a continuing right to reapply, it would have done so in clear language. The silence, therefore, we submit is not an omission to be considered judicially. It is a legislative choice reflecting a balance between humanitarian protection and administrative closure. And I should say that the respondents agreed with us. In fact, if the court has regard to the core bundle, bundle 1, on page 56, this is the letter from the UCT Refugee Rights Clinic that commences this entire litigation. And paragraph 1, they set out who they act for. Paragraph 2, they say our clients have previously made applications for asylum and have all received a final rejection from the Standing Committee for Refugee Affairs in terms of section 25(1) of the Refugees Act, and then they attach copies of their final rejection letters. However, due to changed circumstances in our client's country of origin, they are unable to return to Burundi without the risk of facing persecution or serious threat to their life, safety, and physical freedom. Therefore, our clients wish to make a surplus application for asylum, which is a principle recognized by international refugee law. Then they quote again what the handbook says in paragraph 4. And the crucial paragraph on page 57 is paragraph 5. Here, the respondents say that South Africa has ratified and is party to the 1951 Convention relating to the status of refugees, but has not established a policy relating to the procedure of surplus asylum applications. This is an unfortunate gap in our law, as foreign nationals cannot be returned to their countries of origin if there is a risk of persecution, of a threat to their life, safety, or physical freedom due to the principle of non-refoulement. Now that's a critical paragraph, because right out the gates, the respondents recognize that there is a gap in our law. The question then becomes, can you fill that through a mandamus? And our submissions are that you cannot, because a mandamus is about an existing right, not a lacuna in the law. And the amicus, the court would have seen, agrees with our reading of the Refugee Act. They repeatedly state that there is a lacuna in the Refugee Act, that there should be a process, and they go as far as to offer their assistance to the department to fill that particular lacuna. And so the respondents in their first letter, our reading of the Refugee Act, as well as the amicus's reading of the Refugee Act, is that there is a gap. And we say that the proper course that they should have followed is not to seek a mandamus, but to bring the necessary constitutional challenge, as this court has said in My Vote Counts, that where an act insufficiently protects a right, your course is to either rely on the act as it is, or to bring a constitutional challenge to deal with the insufficiency. And we say that the process that the SCA followed seemed to agree with us. If the court regards volume 5, the SCA judgment, on whether the right to reapply in fact exists, I'm reading now from page 500, paragraph 75. The SCA says, this brings me to the Refugee Act. This is after they reject the interpretation that non-refoulement is absolute, and the context in which the principle of non-refoulement should be construed. The legislation does not, without more, contemplate that applicants whose applications for asylum have been lawfully refused can remain in the country and simply resubmit their applications. A new application can only be brought based on a substantially different or changed circumstance. That's the only part in which we disagree with the SCA, and I'll deal with that in a minute. An application brought on the same facts would likely constitute an abuse of the asylum process. Absent a new basis or new facts, a failed applicant for asylum is not entitled to make one after another. There has to be finality to the process. Therefore, the suggestion that one can, without more, submit one application after the other when the previous one has been finally determined is not what the Refugee Act contemplates. For such applicants, the period between the final rejection of their asylum and their departure is regulated by the Immigration Act. Without any permit to remain in the country, such applicants are regarded as illegal foreigners as defined in the Immigration Act. Section 32 of the Immigration Act provides that any illegal foreigner shall depart unless authorized by the department to remain in the Republic. Thus, a failed asylum applicant can only remain in the country on either of the following bases: that the final determination of the asylum application is pending, that he or she is authorized by the department to remain in the country, or that there is some other lawful basis to remain in the country. Now, I have submitted that we've agreed.
Ramokgale,
Yes, Deputy Chief Justice.
you hear that buzzer?
I did, scaringly so. I take it it's now the time for questions.
It is indeed.
Yes.
Yeah.
Could I just make this one final submission to tie it up? So what I was submitting is the SCA, on our understanding, gets the law right, with the exception of finding that absent a new fact or substantial change, there is no right to reapply. The question then becomes, where does the SCA get that absent a new fact or substantial change, there is no right to reapply? And on the judgment of the SCA, it reached that conclusion on reading foreign case law. It looks at the UK.
I thought you were making one submission.
Oh, I was tying up this particular submission. I apologize, Deputy Chief
You'll
Justice.
tie it up during question time.
Yes, all right.
Mr. Ramokgale, you've referred us to the reasoning of the SCA, and I want to take you back to paragraph 71
Yes, DCJ.
of the SCA's judgment.
Yes, I have that.
That's where the SCA clarified what the reach of the non-refoulement principle is.
Yes.
And, sorry, you've dealt with what the reach of this is, but this is what the SCA says, but once these processes are exhausted and an asylum application is finally rejected, the protection falls away.
Yes.
That's your submission.
Yes.
Because it then explains, it says, that's the essay, for it is implicit in that rejection that the claimant does not meet the definition of a refugee.
Indeed.
And in 72, the SA says, under those circumstances, requiring them to return to the country from which they fled would not violate customary international law.
Yes.
You agree with that?
Yes. Yes, we do.
So, what I want you to clarify for me is, this was on the basis that they came as asylum seekers. They applied for refugee status. They didn't get it. They never left. The SCA then says, no, department, consider their reapplication. Your argument is, I want to understand it, is their status has never changed. They left Burundi as asylum seekers. They remained asylum seekers. They applied, they didn't get it. There was no change in status for them to become surplus applicants.
Yes. So, Deputy Chief Justice, if I'm understanding the question correctly,
Yeah.
what we submit is there is a process that an asylum seeker goes through, and this is what the SCA defines as non-refoulement and the shield falling away. The issue then becomes, if there is a changed circumstance and a person is not a surplus refugee, in other words, when they left their home country, they were not seeking asylum, what becomes of that particular party? The way that the UK, New Zealand, and Canada have dealt with it is that they have legislated for fresh asylum applications after an application has been rejected. Our Refugee Act does not do that. And so there are three categories, if one could say.
So what you're saying is, in essence, what the respondents did was to bring a fresh application for refugee status.
Indeed.
Because they brought one that was rejected.
Yes.
So they're bringing another one. That's different
Yes.
to someone who says, things are bad in my country.
Yes.
Please recognize me as a refugee here.
Yes. So what we're submitting is...
Because I've been okay so far.
Yes. So what we say as we understand the respondent's case is we say that there's a confusion between a surplus refugee and a reapplicant. And we've gone through the source of of a definition of surplus refugee, and that's paragraphs 94 and 95 of the handbook from the UN. And it tells you that when a person leaves a country not fleeing persecution and a change of events results in them seeking refugee status, they need to apply. Now, the department has no issue whatsoever with that kind of party because they would not have had the benefit of the process and the application.
Yeah.
That's very different to someone who has had the benefit of the process, has been finally adjudicated, and then wants to apply again.
So your case is what these respondents did was to simply reapply, and that flies in the face of what the SCA said cannot happen.
Absolutely.
In paragraph 74.
Indeed. Indeed.
So it's a reapplication.
It's a reapplication, Deputy Chief Justice, yes.
Thank you very much.
And our submission, you can only reapply if the statute allows you to do so, because we're dealing with a mandamus application.
Yeah, because I think the SCA says if their construction, meaning the respondents, were correct, there would never be an end to a cycle of asylum applications.
Indeed.
I do not think that the principle goes as far as to suggest that once an asylum seeker makes an application, he or she will never be returned to their country of origin, irrespective of the outcome of such an application or its final determination.
Indeed.
You agree with the SCA?
Yes, absolutely.
Thank you.
Absolutely.
Mr. Ramokhala,
Justice Mhlahla.
just please help me with the definition section of definition of abusive application for asylum
Yes.
and the reference to that term without any substantial change.
Yes.
What does it mean? Because it refers to one or more prior applications.
Yes.
What does that mean?
So,
And where does it fit in this case?
yes. So, Justice Mhlahla, we have 4 submissions on that, on the question about an abusive application. The first is that we submit that the fact that the statute contemplates a particular behavior that does not mean that it creates a right to engage in that behavior. So legislation, as the court knows, often anticipates unlawful or undesirable conduct. It doesn't mean that you have an entitlement to that particular conduct. And so, if anything...
Would one be entitled to make an application? Let's say, please take the current applicants. Their application for asylum had been rejected. Then there are these substantial changes that come to their attention
Yes.
that make it impossible for them to return to their country of origin. Would they then be entitled to then bring an application, a new application that says, yes, our application had been rejected, but due to the substantial changes in our country, we're lodging an application?
On our understanding of the Refugee Act, no, Justice Mhlahla. And we say so because all that the Act says is you may not bring an abusive application. It doesn't say you may reapply. And they rely, and you'll see where that particular bit about abusive application comes from. It's in the definition section of the Act. And so they seek to invoke a substantial operative right from the definition section of an Act about what the RSDO may reject. To succeed, they must demonstrate a clear right to reapply, not a right to bring an abusive application. Because their argument, taken to its logical conclusion, is because the Act prohibits abusive applications, we have a right to bring an abusive application. What they need to demonstrate is that the Act contemplates a reapplication in and of itself.
And you're saying there is no provision in the Act for that kind of an application?
No, there isn't as such. And if the court were to regard, for instance, and we set out extensively in our heads of argument the specific pieces of legislation from the UK, from Canada and New Zealand, which the SCA relies on, it expressly recognizes abusive applications, it expressly recognizes a right to apply and a right to reapply on the basis of a fresh claim. None of that exists under our Refugee Act. And because if one were to give that kind of interpretation, that there's that abusive application means that the Act contemplates one or more prior applications, it really would be turning the statute on its head. Because what then becomes of Section 24(5) that says once this has come to an end, this is the outcome. Finality is what it requires. And so we say there's nothing outside of that definition section gives an entitlement. There's no statutory entitlement, which is the reason why even in their founding affidavit, the respondents or the applicants then could not identify a single provision of the Act that entitles them to reapply.
So there should have been a specific provision
Indeed.
in the Act that would then not for them to rely
Yes.
on what is contained in the definition section.
Yes, indeed. It's the only statutory hook from the respondents' cases we understand it is that bit about one or more prior. But that's prohibitive, not enabling. So you may not bring an abusive application, not that you are entitled to bring an abusive application.
At para 79 of the SCA judgment, the SCA seemed to have, in a way, used what we used in Ruta, where we said, when a person asserts that I want to apply for asylum, you must give that person the opportunity to do so.
Indeed.
In this particular matter, the court said, the SCA said, by asserting surplus claims, then the department should have done something and not just say, no, we're not. You should have, as a department, determine the application, decide whether it's genuine or not.
Yes.
But not just say, just because you had been refused asylum, we no longer have to come into the picture.
Yes.
We say,
Well, two things, maybe three. I often say two and then I say a third point. The first is that the SCA's finding on that was based on its comparative analysis of the UK, Canada, and New Zealand. The problem with that comparative analysis is that all of those countries have expressed authority on their RSDO's equivalent to consider fresh applications on a substantial change. The Refugee Act doesn't have that. And so we say the SCA was not comparing like for like. It was comparing apples and pears. The second is the department can only do what the law authorizes it to do. If the Refugee Act doesn't allow more applications, then the Refugee Act simply doesn't allow more applications. They can't do that, otherwise they would be subject to a legality challenge. And so our answer to that is, if the statute says so, we will happily do so, we'll consider the applications. But on our reading of the Refugee Act, there is no right to reapply. And in Ruta, a Ball, Saidi, all of those decisions, Ashebo, were all about parties who had not had the benefit of the process, who were first-time applicants, not re-applicants. And so that's our answer to that, Justice Mhlahla.
so what the applicant should have done is to, in your argument, challenge the legislation and say there's a defect, we don't have, this particular provision is not in the Act.
Indeed, Justice Mhlahla. If there was a constitutional challenge, we would be having a very different debate this morning. And I pointed the court to the letter that started this entire litigation process. In paragraph 5, they say there is a gap, there's a lacuna. You can't fill that lacuna with a mandamus. You have to bring a constitutional challenge that says the Act insufficiently protects these rights, it insufficiently doesn't cover South Africa's international law obligations. But because it's a mandamus, they must found an existing right on the law as it sits today.
Thank you. Thank you, Mr. Chair.
Thank you, TC. In your debate with Justice Mhlahla, you said that you have got 5 submissions to make in relation to the point about Section 1.
Yes.
Can you finalize those? You mentioned one and then you continued with something else.
Yes, yes. I've in the course made the submissions, but if I could just highlight what those are.
Please.
The first is the argument I've made, which is that the fact that the statute contemplates a probative act doesn't give you an enabling power. So in other words, it prohibits abusive applications, it doesn't enable abusive applications. So that's the first submission that we've made.
I've got that.
Yes, Justice G.
I'm saying I've got that.
Yes.
Continue.
The second, sorry, I'm just having a look at my notes, apologies. The second point is about the fact that the statute doesn't have provisions that apply for reapplications. So the abusive application is in the definition section, but there is no operation or operative provision within the body of the act itself that says there's a new or fresh application that may be considered under the following circumstances to be decided by this particular official under these circumstances, etc. That's the second argument, the absence of a statutory text to give a right to re-entitlement. The third point that we were making is that to read the Act as requiring abusive applications or prior applications would defeat finality, which is set out in Section 24(5). That once the process has come to an end, you must be dealt with in terms of the Immigration Act. But if you were to follow the interpretation given by the respondents, which is we are entitled to bring one or more applications, what does that mean for Section 24(5)? The Act would be inherently inconsistent because you could always defeat 24(5) of the Refugee Act by simply bringing another application and another application and another application. And so the interpretation that the court must give to the term abusive application must also consider 24(5) so that it doesn't become superfluous. Those are essentially the 4 points that we were going to make, but the others aren't so important.
Okay, thank you. And in your debate with Justice Mhlantla, you said that even if, for instance, I'm asking this, let's leave the facts of this matter aside.
Yes.
Let's say there's a genuine application. This person came to South Africa and not as an asylum seeker, right? And then in the process of them being here, they then learn that things are bad in their country. And you're saying that if that person had applied and his application had been refused, he would still not qualify, even if it's a genuine application.
Yes, on the statute as it sits currently, Justice, because what I was trying to distinguish is a first-time applicant, which could be a surplus refugee or a person who was fleeing persecution, and a reapplication. And so the statute doesn't allow the third category, which is a reapplication. It does allow surplus and ordinary first-time applicants. And so even if there's a genuine change in circumstance, the statute on our reading currently doesn't give you that right. The only way one could get to that is to bring a necessary constitutional challenge to say the Act fails in the following regard. It should actually say this, it doesn't. But one can't achieve that outcome through a mandamus application.
You've also said that the SCA arrived at a decision and made an order against you because it looked at international law.
No, it looked at foreign case law.
At the foreign cases.
Yes, indeed.
All right.
So its judgment sets out the principles. It starts off by the principles of non-refoulement. It looks at the AU Convention, the Refugee Convention, etc. And then it says, we don't have any case law or laws that deal with this particular question. And to answer that, relying on Section 39(2) of the Constitution, it then engaged in that foreign law analysis. But the problem is that it's statutes from another country, not this particular Refugee Act.
Let's look at paragraph 80 of the SCA judgment.
I have that.
Am I wrong to say that they seem to be saying because there's change in circumstances and there are new facts, that is why you have to reconsider the application?
Yes, that is indeed what the court says at paragraph 80, yes.
So basically, they are not saying simply because the situation is like this in other countries, then you must do it. They say that in this matter, it is because of new facts that you must consider the application.
No, Justice Plattler. So that paragraph 80 is the conclusion of its analysis of the foreign case law, because it begins its judgment by stating that there is no law in this country that regulates the situation that we're dealing with here. And so to assist us in dealing,
You're reading from which paragraph?
yes, if I could take the court to, in the judgment, page 482, paragraph 26. At paragraph 26, it says, South Africa has not yet developed a significant jurisprudence on surplus refugee claims. And then in Ruta, it says the court made a passing remark to this issue. This is understandable as a dispute there centered on two issues, etc. As far as we could establish, this is the first case in this court in which a surplus claim was directly asserted. Although we are not called upon to determine the merits of the application, it is important to give some guidance, as to how such claims should be considered. And then it says at 27, given the absence of authority on this issue in our jurisprudence, it is useful to look to foreign law as permitted by section 39(1) of 1C of the Constitution. I do so mindful, and then it sets out the test in H versus Fetal.
And then page 28 then deals with the correspondent. What confused me about your submission about the reliance on the law in the other countries was because when they take a turn, because when you read this judgment,
Yes.
in the main, it seems to favor you until the SCA then said, but in this case, this is the situation.
Indeed.
Yes.
So, yes, so what I'm saying is we are absolutely on all fours with the SCA about the international law obligation on non-refoulement. And we agree with the court's finding that it's not an absolute right. But then the court says, well, if there's a new case or a new fact, then you must consider the application. What we submit is then on what basis? Because if the act says beginning to end finality, how do you restart the process? How the SCA gets there is through that foreign case law analysis. And in our heads, we quote the laws of these respective countries that demonstrates that you can bring a reapplication, which is not present in our law. Because the court will see in the SCA's judgment, it doesn't pin to any provision of the Refugee Act that allows a fresh application as we submit.
Anyway, you're saying there are no new facts because when the respondents flee their country, there was circumstances, unbearable circumstances already.
Yes, and there's a factual dispute about whether the claim is a new basis or not between the parties. The court will see that one of the bases by the respondents is the election of the president at that time, and that he was the cause of all of that upheaval. The department's version is, well, he died shortly thereafter and there's a new president and the UN says everything is fine. But the court doesn't have to go as far as deciding the factual dispute, because if we are wrong that there is a clear right, then the court must order a mandamus and the RSDO must consider all of those particular facts. But if we're right, then the case ends there.
So you agree with the respondent that we should ignore the facts.
Yes, we're saying the case only turns on a question of law. The factual disputes aren't important because, as the court correctly said in Ruta, the appropriate person to make up all of those and weigh up all of those factors is actually the Refugee Status Determination Officer.
Okay, thank you. Thanks, DCJ.
Thank you, Mr. Ramakhali.
Yes, Justice
There
Collins.
appears to be a conceptual debate about what would fit into the definition of a surplus application.
Yes.
There's the definition that says it's a first-time application, and there's other writings that seek to suggest that it may be a second application. Does it matter, though, at the end, given that in any case, at least certainly the UNHCR and the foreign jurisdictions make the distinction between subsequent and first applications? And it almost seemed that in respect of first applications, there's no real dispute about it.
Yes. So the distinction does matter on our framing. And the reason the distinction matters is because the benefit that those foreign countries have is that their legislations have set out processes about how to deal with a second application.
Sure. Well, that's precisely the point.
Yes.
They call them subsequent applications.
Yes.
In their legislation.
Yes, they do. They call them subsequent applications. And so how we started this is we looked at what the source of this law is. And it's the handbook. And there seems to be no debate between the parties about that. The distinction matters for the purposes of whether they have a right. And so we say, for the submissions I've made, that those other countries have set out how to deal with a reapplication, a resubmission, either expressly in their statute or in regulations, which is not the case here, yes.
My second question goes to Section 1B. You say that really it's a definition that prohibits the bringing of abusive applications.
Yes.
But the fact of the matter is that it contemplates subsequent applications. Let's leave the labeling aside for a moment. And one could equally argue that just as much as it contemplates that one may not bring an abusive application, it may well contemplate that one may bring a non-abusive application.
Yes.
One that doesn't fall foul of the definition.
Yes.
What do you say about that?
Well,
That at least it provides, it's just not, it may be cast in the negative depending from which side you look at it.
yes.
That
Well,
may be an enabling one that contemplates the bringing of an application that's not abusive.
yes. No, one certainly could argue that the definition contemplates a non-abusive application. The difficulty is where,
Yeah,
because it doesn't set that out.
yeah.
It's so because the difficulty is that the case is constrained by the fact that this is a mandamus. And so we certainly accept that there might be a way of contemplating non-abusive second application or subsequent applications. When, how, who must consider that? That's the issue.
It seems the problem that arises that even if it contemplates that, and if one reads that in the most favorable light, that you can bring an application, the truth and reality is that application lands inside the Refugees Act to be dealt with in identically the same fashion as any other application. There isn't a special mechanism to deal with subsequent applications.
Yes, there isn't a special mechanism to deal with subsequent applications, but if the court has regard to the statutes that we've referred to from other countries, they set out a different mechanism to deal with subsequent applications.
I'm not dealing with that. I'm
Yes.
saying that if one has regard to the order of the SCA, for example,
Yes,
that order would require your clients to deal with this application in the same way as it deals with a first-time application.
well, we don't know. If I could take the court,
In the absence of any framework,
yes,
except SCA refers to possibly extradited procedures, but we're not sure how one gets there.
Yes, absolutely. I think the SCA says if there's a new basis, go and deal with it whichever way you want to. We are mindful that there might be abusive applications and people might abuse the process, but we leave that to the department to sort out. And so that's why part of the difficulty we're in is we're told to go act in a particular way, but without a framework, which is what the lawmaking process would have benefited from.
Okay.
And the court will recall that even in cases such as Ruta, this court was mindful, not Ruta, sorry, Ashebo, that there's a tension that the department has to weigh up between genuine asylum applications and reapplicants. But without a particular framework, it's difficult to do so. And in fact, I'm reminded in Ruta in particular that there was a debate about whether there is a discretion on a RSDO or the department to issue out a permit once an application has in fact been made. So the court's finding was that there is no such discretion. It's an entitlement as of right. Do the same considerations apply for a reapplicant? We simply don't know.
Okay, let me finally just get to my predicament. The shield of non-refoulement will exist during the course of the processing of an application.
Yes.
And it comes to an end when that application is finally disposed of. In the real world, there may be changed circumstances that arise after that.
Yes.
In the country of origin, for example, that would place that person at risk if the person was returned to that country. Now, under those circumstances, how does the guarantee of non-refoulement, which appears in Section 2
Two,
of
yes.
the Act, in unconditional terms, and it's been described as a remarkable provision, one unprecedented in the history of our country's enactments.
Yes.
Let's assume that those circumstances that arise in the country of origin would place such a person at risk.
Yes.
But that person has already applied and has exhausted on the basis of set of facts A.
Yes.
What would happen to such a person, and does the guarantee of non-refoulement not lend itself to the conclusion that one must say that that person cannot bring an application in the High Court to interdict the government from returning them,
Yes.
pending what?
Yes. Well,
If there's no right to apply,
yes.
then you can't have an indeterminate interdict in place.
Yes.
And that person should be, that guarantee must mean something.
Yes. Yes. Well, Justice Colopin, that's precisely the difficulty that we are in here, with respect, that there might really be genuine instances where someone cannot be returned to their home country and a new circumstance has arisen. But I go back to the submission I made earlier that the department can only do that which the law authorizes. And if the law doesn't authorize a reapplication, the remedy is not to simply squeeze one in. It's to do what I would have thought the respondents would have done when they identified this gap in 2018, which is to bring a constitutional challenge. And as the court knows, there are constitutional challenges about deficiencies in legislation. Always attached to that is a Part A application saying, pending the outcome of this should be the position. And so that could have happened, but unfortunately we're not there. We're in the world of a mandamus, and that is framed by whether there's a clear right or not.
So absent that framework, a party in that position would have no remedy at all.
Absent the framework, there is no remedy as matters stand. Yes, and that's the, you know,
And then, in the absence of such a remedy, we must accept that the guarantee in Section 2 is quite hollowed out then.
No, Justice Colopin, because as the SCA has says, it's not an absolute guarantee. The process must come to an end.
Yes, but the SCA itself contemplated a new shield coming into place.
Yes,
So when
indeed.
the SCA says the process must come to an end, it referred to application 1.
Yes,
But then from paragraph 80 onward, it contemplated that you could bring a second application under changed circumstances.
yes.
And then it must have contemplated that the shield will be reinstated.
Indeed, if there is a right to reapply, then absolutely the shield applies. And as I've submitted that if we're wrong on that question of law, then the department must be ordered to consider the reapplications. But our submission is that, at least the version given by the respondent, is that non-refoulement comes to an end. In non-refoulement, there isn't a right to bring a reapplication. Non-refoulement operates in a particular framework, finality, and whether there's a genuine fear of persecution. The SCA says once that has happened, then the shield falls away. If there is a right to bring an application, it can't be sourced, a reapplication rather, it can't be sourced in a foreign law comparison. It has to be on the statute as it stands. And so the court has then met back with the difficulty in Section 2 about non-refoulement. And the question is whether non-refoulement entitles a reapplication, and a reapplication, when does it end? And those kinds of difficulties would have been resolved, we respectfully submit, in a legislative law-making process, as was done in the UK, etc.
And you're saying the applicant or the respondents having identified that particular problem then should have chosen that option?
Indeed.
Okay, thank you.
Mr. Ramakhali, just to proceed from the questions of Justice Colopin, you indicated at the beginning of your argument, you gave an example of the Palestinian,
Yes.
who then, after the 7th of October 2023, would be in a different situation.
Yes.
Let's just presuppose that that Palestinian had applied for refugee, had applied for asylum,
Yes.
but had been refused it on the grounds that it was just the same as any member of the population, they'd be subjected to this.
Yes.
But then comes the 3rd of October, was it the 7th of October? you seem to imply that thereafter the situation had changed and that refugee would have a right to asylum. But on your version, because they've applied the first time, too bad, we send them back to a country where there's a genocide.
Yes. Well, yeah, well, Justice Nichols, I accepted the difficulty, and it's one that we pointed out. But as I've said, the department has to act within the constraints of the Refugee Act. It can't do no more in a mandamus application than that which the Act contemplates.
So in that situation,
Yes.
they would be returned back to Palestine.
Yes, because regrettably, that's precisely what Section 24(5) says. That once you've had the benefit of the full process, you are to be dealt with in terms of the Immigration Act. Had there been a process of subsequent or further applications, that would have been set out. And that is a lacuna in the law. We absolutely agree with the respondents on that. The only question is, how do you fix it in a mandamus application?
Basically, your argument is that a second application can never be entertained on whatever basis.
On the current framing of the Act.
Current framework.
Yes, currently, yes.
Mr. Ramohale, could I just follow that one up? What of an appeal in relation to changed circumstances? Where does that fit into the mix?
We deal with this, Justice Savage, in our heads of argument, where there's a judgment, and I'll find it in our heads, that essentially states that when a party is in the process of an appeal, they are entitled to basically set out a wholly new case on appeal or review. But that's before you get to the final determination of the process. There you are, it's what's called a wide appeal. You are entitled to raise an entirely new case in that appeal process. So,
Palestinian example, would it be open to the Palestinian individual then, to refugee, to then bring an asylum, to ask for an appeal on new facts for the application to be reconsidered under 24B5? Is that
yes, so they could notionally bring an appeal, reopen the appeal, the necessary condemnation of whether the story is, and there they could throw in as many new facts as they would be entitled to. But what they wouldn't have is a right to start the process again with an interview and a review board, etc., etc. Yes.
constraints on the appeal?
As I understand it, we refer to the decision of the High Court. I'm just not sure whether it's been endorsed by this court. It's in our heads of argument in paragraph 86, the decision of Tantouche versus Refugee Appeal Board, where the court said, the applicant has transiently criticized the RAB's misinterpretation of the nature of function as an appellate body. As explained, because of the RAB's powers to gather additional evidence, the intention of the legislature was to confer upon the RAB an appellate jurisdiction in the wide sense, meaning that it is not bound to pronounce within the merits within the four corners of the record of the RSDO. An ordinary appeal is one where the appellate body is confined to the record of the body being appealed against. A wide appeal is one in which the appellate body may make its own inquiries and gather its own evidence if necessary, and etc. So, and I think even in our application for leave to appeal, we say the remedy on the current framing of the Act would be to bring a wide appeal as contemplated in Tantouche, but it's not a reapplication process. It's set out in our application for leave to appeal, yes.
Can I ask you to assume, for purposes of my questions, that when Ms. Irankuda left Burundi and up to 2014, when her application was finally rejected, circumstances in Burundi didn't entitle her to refugee status? In other words, there weren't refugee circumstances prevailing. But I ask you to assume, for purposes of my questions, that those circumstances were in existence by 2020.
Yes.
I understand your argument to be that if a person from Burundi who was just illegally in South Africa made a first application in 2020 and those circumstances were accepted by the RSDO, that person would be awarded refugee status.
Yes, for the purpose of the question, indeed, yes.
Ms. Irankuda tried to persuade an RSDO in 2014 or earlier that those circumstances prevailed but failed. And since that is not challenged, we must accept that Ms. Irankuda, like my notional illegal immigrant in 2020,
Yes.
Was a person who left her country and as of 2014 was not a person who was absent from her country because of the existence of circumstances contemplated in Section 3. But you say because she failed in her first application, she is precluded from receiving the same treatment as the person who didn't bother to apply in 2014 but did apply in 2020.
Yes.
Why, given that the 2014 rejection stands, why is she in a different, why is Ms. Irankuda in a different position from my notional illegal immigrant? Because she is a person who, like that person, left her country and was in South Africa as of 2014, at a time when circumstances did not yet exist entitling her to refugee status. Why is she not exactly similarly placed to my notional illegal immigrant?
Justice Rogers, it might very well be that they might be in the same position. The only question is whether there's a right to reapply for the person who applied in 2014 and then seeks to apply again later. And again, because we're dealing with whether there's a clear right or not, it might very well be in a proper constitutional challenge that the court strikes down the failure to legislate for such a situation. But that's not where we are.
Well, since your answer to questions that some of my colleagues have posed is not to say that it is right and just and in keeping with the non-refoulement principle that the Palestinian should be returned to Gaza in 2024, you say it's a lacuna. The Act can't be interpreted in a way to avoid that outcome. So perhaps that is something I now just want to explore with a couple of further questions. Section 3 sets out that a person qualifies for refugee status for purposes of the Act, and then the circumstances are set out.
Yes.
Reading Section 3, Ms. Irankuda did not qualify for refugee status in 2014, but she did in 2020. And the way Section 3 is formulated doesn't say that she doesn't qualify for refugee status because an earlier application failed. It's absolute in its expression.
Well, with respect, no, Justice Rogers, because if we, on the facts, on the factual dispute, the circumstances alleged by Ms. Irankuda.
I've asked you to assume my
If it's
of my questions.
Yes, well, so what Section 3 does is it tells the RSDO who qualifies for refugee.
Well, it says a person qualifies for refugee status.
Yes.
If. So Ms. Irankuda didn't qualify for refugee status in 2014, but she did in 2020.
Yes.
And Section 3, at any rate, doesn't say that she didn't.
Yes. So I readily accept what Section 3 says of the
Section
Act.
5 tells us when refugee status ceases.
Yes.
And the fact that an earlier application failed is not a circumstance which causes refugee status to cease.
No, yes, no, that's correct, Justice Rogers. Again, the difficulty is all of these provisions, 3, 5, 1, and 2, have to be read together with Section 24.5.
Now let's go to Section 21, which is the right to apply for refugee status. I don't read in that section anything that says that it can be done only once.
Yes.
There's nothing that says it can be done only once.
No.
It doesn't say it can be done twice, and it doesn't say it can only be done once. It's
Yes.
open-ended.
Yes, that's absolutely right. But so on our interpretation of that, that has to be met together with 24.5.
Which is that they must be dealt with in terms of the immigration.
After the process has come to an end, yes.
Now, my notional illegal immigrant in 2020 who had never previously applied for refugee status must also be dealt with in terms of the Immigration Act.
Indeed, yes. Because that's
So the fact that you must be dealt with as an unlawful immigrant and are susceptible to deportation,
yes.
whether you have made a previous application or not, that is the law. So my notional immigrant in 2020, although she must be dealt with in terms of the Immigration Act, we know from the authorities of this court that that doesn't override her right to apply for asylum.
Yes.
So the fact that an unworthy 2014 application is rejected and that that person now falls to be dealt with in terms of the Immigration Act
Yes.
puts them in the same status as any other unlawful immigrant. there is nothing in Section 24 itself which says that that person cannot bring a second application under Section 21. And at least if it is open to what I'm putting to you, you say we must hinge everything on the fact that there's a provision in the Act which says that once an asylum application has been finally rejected, the person must be dealt with in terms of the Immigration Act. So we know that they must be dealt with as any other unlawful immigrant. But we also know that unlawful immigrants are not precluded from seeking asylum.
Yes.
So in attaching the significance that you do to that provision in Section 24, you are asking us to give an interpretation to the Refugees Act which creates the lacuna and the potentially catastrophic results for individuals that were put to you in relation, for example, to the notional Palestinian, and it could be in relation to Ms. Irankuda. I understood the department to say that if she went back, and let us say the circumstances are dreadful there, and if she is not raped or killed or otherwise dealt with, if she goes back and immediately comes back into South Africa, she can then apply for asylum.
Sorry, Justice Roger, there was quite a few questions there, so if I could...
So I'll remind you of the earlier one. Go back. Is it the department's position that if Ms. Irankuda only goes back to Burundi, if she does that little formality and therefore comes in again, she can apply for asylum?
No. I'm trying to get away from the factual disputes, but the position is set out in the answering affidavit. And
we must interpret the Act against a possibility that a change of circumstances may arise which may make it dangerous for the person to return.
yes, no, so what I'm saying is on that particular factual dispute and the email, the department says that that's an incorrect understanding of its position. And I don't want to go there because it has little to do with whether there's a clear right or not.
Yes, so that's why I'm putting it to you as a hypothetical.
Yes.
Suppose those circumstances have arisen and prevail now in Burundi, as they might in Gaza.
Yes.
Do you say that as long as the person goes back to that country and then re-enters South Africa, they can then apply for asylum?
No.
Or is the door forever closed?
No. So I want to be clear on that if there is a right to reapply, non-refoulement would operate. They cannot be returned to their country of origin. They cannot go back. But that is contingent on whether there's a right to reapply or not.
So I'm not sure I'm following. Assuming Ms. Irankuda didn't apply, but went back to Burundi, and managed to survive assuming there were very dreadful circumstances there, and then immediately came back to South Africa, could she then apply for asylum?
No, so the position of the department is, one, if there's a right to reapply, non-refoulement operates. There is no obligation on a person who has an entitlement to reapply to go back to their country of origin.
And that requires us to read Section 21 as containing an implicit prohibition against more than one application. And
Yeah.
that, you say, flows from a provision which requires the unsuccessful applicant to be treated as an illegal immigrant.
Yes, and that's not just our position, Justice Rogers. It's the same position adopted by the amicus. That there is a gap.
Well,
And
I'm interested in what position this court should adopt, which is, and we are mandated to adopt an interpretation of the Act,
Yes.
if at all possible, that avoids potential constitutional invalidity. Now, if Section 21 doesn't prohibit a second application, and you seek to infer that from a provision in Section 24 that says that they must be dealt with as an illegal immigrant, you have to persuade us that that injunction, that they are now to be treated under the Immigration Act, puts them in a different status from an illegal immigrant who has not yet brought an asylum application even once, and who must also be dealt with in terms of the Immigration Act. Why do you say that your interpretation is so compelling on that point?
yes.
That we should read Section 21 as prohibiting a second application?
So our case is this. The court has to read non-refoulement in Section 2. It has to read the interpretation, the prohibitive provisions of Section 1 about abusive applications. And it has to read Section 24(5) together with the principle regarding finality. So one can't, with respect to Justice Rogers, look at one provision of an act and say, well, it doesn't preclude the application. The court has consistently said you read a statute holistically.
Are you
in a-
referring to anything other than Section 24(5) as a basis for saying that Section 21 must be read as allowing only one application?
I am also relying on this decision in Ruta, in Abor, and Ashebo that says once the process has come to an end, the shield falls away.
Yes, I don't think either of those cases were directed to circumstances where where by virtue of a change of circumstances, the protection of non-refoulement was needed. Neither of them were concerned with the issue we are now concerned with. But as a matter of interpretation, having regard to the text of this statute, its purpose, and constitutional interpretation, is there anything you rely on other than Section 24(5) for the proposition that there cannot be a second application under Section 21?
Well, we also say that it's not there.
Sorry?
So we also say that it's not there. There is no provision of any on any provision of the Refugee Act that entitles a second application.
Silent as to whether there can be more than one.
Absolutely. And on our reading of it, together with Ruta, together with 24(5), together with the question Justice Colopin put to me, which is, what is the framework for a reapplication? When does it end? Who decides it? That one can't simply assume in a mandamus application that that particular absence means nothing.
Now, another part of the text, which seems to me to be very important in deciding whether Section 21 prohibits a second application, is the definition of abusive application. Because that definition now makes sense if one accepts that Section 21, albeit read with your Section 24(5), doesn't prohibit a second application, but it does treat it as abusive in the absence of changed circumstances.
Yes, indeed. So our interpretation is that absence, again, I go back to this, which is that the silence actually means something. And in a mandamus application where you have to demonstrate a clear right, it has to be hooked on something. And our interpretation is, I'm sorry to interrupt,
No.
that when you consider this court's jurisprudence, the finding of the SCA itself about how non-refoulement operates, which is it comes to an end when a process has finally been determined, and the position adopted by ourselves, adopted by the amicus, and by the respondent that there is a lacuna in a mandamus application that can't be filled in that way. Yes.
There's only a lacuna if Section 21 must be read as permitting only one application, and that's what we've been debating.
Yes.
You say that must be understood in the light of Section 24(5).
Yes.
We've already debated why that may not be a particularly compelling reason, given that all illegal immigrants must be dealt with in terms of the Immigration Act. But what might be, I would have thought, of considerable significance when one comes to text and context is the definition of abusive application, because sub B of that definition refers to after the refusal of one or more applications. Now, it's all very well saying that it's a definition section, it can't confer rights, but on the other hand, we mustn't lightly infer that the lawmaker passed a nugatory or futile provision. So if that is to have any meaning, the meaning must be that under Section 21 you can bring a second application, but that under certain circumstances it may be classed as abusive.
Well, on our reading, that's not the case. Yeah,
Well, tell me why you say Part B of that definition was included in the Act.
well, I've given 4 reasons for that. And the thrust of the reasons is that the court must look at what abusive applications means in the context of the entire Act and the process. Now, if the process has come to an end, if we take the notional illegal immigrant that you put to me, Justice Rogers, who goes through a process, who, as a result of changed circumstances in their home country, had been a previous applicant and seeks to apply again, the question becomes whether they have that right to, in fact, apply again.
So what,
Now,
what
if I may,
application contemplated in paragraph B of the definition?
excuse me,
What is the application which says one or more applications? What
Yes.
are those applications in the definition?
well, one can't rely on this particular provision to say there's an entitlement to bring one or more
Now, I
applications.
just know what applications are contemplated in paragraph B,
No, it could be an application for asylum.
which has
But-
been rejected.
No, Justice Rogers, because one has to ask, again, the case is about a mandamus, with respect. Is there a clear right to the entitlement? And the only way only place in the entire statute that deals with one or more prior applications is a definition of abusive application.
Are you saying that this, an abusive application is when the refugee has one application pending and brings another?
That could very well be.
It seems to me the lawmaker was then contemplating a very obscure and unlikely scenario.
I don't accept that at all, Justice Rogers. I don't accept it because...
But that is the only... You have to resist the proposition that what the lawmaker is referring there to is a previously rejected application, because then that provision is nugatory.
Well, the only way on that is if there's an entitlement to bring one or more previous applications.
That's what we're debating. We can't interpret Section 21 and decide whether it confines a person to one application or permits more without reading the whole Act.
Indeed.
And the definition of abusive application is part of the whole Act.
Yes.
So we must, as far as possible, read Section 21 in a way that is consistent with the definition of abusive application.
Indeed.
And that appears to envisage that there may be more than one application.
Yes, but the question becomes whether there's an entitlement to bring more than one application. Is there a clear right to do so?
Entitlement to more than one application, it can't be lodged.
No, on our submission, no, Justice Rogers. One can't rely on a prohibitive provision to say it sources a right of an entitlement.
Well, I think we're going round it.
Yes.
I've invited you to the points
Yes.
for me. If I can just say this.
Yes.
If the trend underlying my questions were right, and therefore a second application is permitted, it might be that the Act is not, that one might want provisions in the Act or perhaps in the regulations which ensured that repeat applications were swiftly processed so that they did not become a method of abuse, but that they do not inherently have to be such,
Yes.
shown by other countries which expressly permit a second application.
Yes.
There ought to be able to be procedures to accommodate this, and in fact, even within the framework of this Act and the regulations,
Yes.
there is nothing that would prevent the department from expediting a repeat application.
Yes, and that seems to be the problem that the SCA says we need to deal with. It says you will come up with a process or procedure to deal with what we say is an entitlement under the Refugee Act. But again, I go back to the debate I had with yourself, Justice Rogers, that the framework doesn't allow that.
I might have given a slightly different answer to the SCA. I would have said, well, Section 21 allows you to do it. But if it's abusive, you're going to be knocked out pretty quickly.
Yeah.
That you and I perhaps differ on that. In
Yes,
fact,
but that can be legislated for. But yes, Justice Rogers, indeed.
Thank you.
Thank you, Mr. Rampal.
Thank you very much, Deputy Chief Justice. Those are our submissions.
The court will adjourn for 20 minutes.
Good day once more. Let us be ready. Thank you.
Mr. Simmons?
Thank you, Deputy Chief Justice. Justices of the Court, I intend to deal with the submissions made by my learned colleague and with the questions of this Court by addressing 4 broad topics or issues. The first is to understand the right of non-refoulement, its purpose and its context, and to expand upon how, once properly understood, it is apparent that the interpretation offered by the applicants in this matter, the Department of Home Affairs, hollows out, to use Justice Colopin's word, the true meaning and the true purpose and the goal and the lodestone of that provision in a way that is simply untenable. Untenable in principle and untenable as an interpretation of our law under our Constitution and this Act. Secondly, I wish to address certain of the confusions which have arisen about surplus applicants versus what I would call re-applicants or repeat applicants. The confusion we submit does not arise on the applicant side. My clients are surplus applicants and repeat applicants. The confusion has arisen because of the slightly inconsistent stances and arguments made in the course of this matter by the Department of Home Affairs, and in particular, their initial stance which generated this litigation, which is that they will not accept a person to reapply unless they return to their country and then come back to South Africa. In other words, they won't accept surplus applicants. But thirdly, I wish to address, was perhaps the main focus of the debate before this Court with my learned colleague, which is there a right to reapply? Can we look at the provisions of our statute, properly interpreted under the Constitution, under international law, and see there a right? And we submit yes, explicitly you can. And once you see that and you recognize that all of the concerns about whether a constitutional challenge would have been better and not a mandamus, all of those fall away. And then lastly, I wish to address the arguments made so far in writing about the concerns of a floodgates opening, the idea that upholding the interpretation of my clients would mean that there will be some kind of never-ending cycle of endless asylum applications. We will reveal how that concern is unwarranted. So before I launch into those, my learned colleague did not address the question of leave to appeal. He focused on the merits, and I will be following in his footsteps because we accept in this matter that this matter raises a constitutional issue. We accept it raises a novel question of law, and we accept that it's an important question. Where we do differ and why we have opposed leave to appeal is because we submit that the order granted by the Supreme Court of Appeal is inarguably correct, and therefore no sense would be made in granting leave to appeal. But in order to prove that, I must address the merits, as my colleague did, and so it is to the merits that I will now be turning. So to the first submission about, let's call it the fundamental principles and realities of refugee law. The Court presumably does not need me to quote again from Ruta and from Abore and from Saidi and the many judgments of this Court which have reiterated the remarkable quality of the right of non-refoulement, its deeply lodged status, its fundamental importance in the scheme of refugee law, and the way that it operates notwithstanding any other provision in the Act or any other law. All of that, with respect, is well established by the jurisprudence of this Court. It is inarguable. And I will point out that the amicus have filed further submissions drawing on international and foreign authorities, also underlining the importance of the right of non-refoulement. And once you understand that idea, one can say, why is it so important? What is it that has placed this principle at the heart of one of the world's great human rights protective systems? And it is because what we have said in refugee law is that when the unfortunates of this world, the wretched of the earth, come to our country, fleeing certain horrific persecutions, be it war, be it discrimination, be it torture, whatever it may be, we will not send them back. That's it. That's the right of non-refoulement. That's the core of refugee status. And we do not send them back, not because they have some sort of procedural protection, but because we will play no part in sending any person to face those kinds of consequences. What they face in their home country is so unconscionable that we simply cannot justify under our law, our constitution, our system of values, sending them back. The question was perhaps put by Justice Nichols. Imagine a Palestinian facing what our own government and some of our finest lawyers have argued is a genocide. If that person has, by chance, for whatever reason, a previously failed refugee application, must the consequence of that be to be returned into the teeth of genocide? And the answer must be no. And the second inarguable reality about refugee law is simply that the world does change. Countries get better and they get worse. Governments rise and fall, wars break out, and sometimes they occur very swiftly. The Palestinian example on the 7th of October 2023 is an example, but you can pick, unfortunately, your examples. Just to point out a few, a mere 9 days ago in Tanzania, one of our neighboring countries, there was an election in which the opposition leader was in prison, facing death penalty charges for treason, and the incumbent party claimed to have 97.66% of the vote. And there are already allegations of hundreds or perhaps thousands dead of opposition supporters. Now, the point isn't that particular set of facts. The point is the world changes, and when it does, what do we do with, in this example, the Tanzanians who might be here, who had unfounded applications in the past, but now the world has changed, and they have a fresh application. And the application in the past simply did not consider these new considerations because it is a new set of facts. And with respect, my colleague has given no answer to this question. Part of his submissions was that there doesn't need to be an answer, that there's a misunderstanding of the right of non-refoulement. And he based that in part on a reading of the judgment of the Supreme Court of Appeal. And I'm going to read exactly the same paragraphs of the SCA judgment, because with respect, we submit that they support our case and not that of the applicants. Those are the paragraphs beginning at paragraph 71 at page 499 of volume 5 of the record. And I believe some of them have already been raised, so I'll try and move swiftly through them. There was an emphasis, I believe, by the Deputy Chief Justice on the line, it's the fourth line in paragraph 71 at the bottom. Once these processes, the asylum processes, are exhausted, and an asylum application is finally rejected, the protection falls away. And in my learned colleague's head, that sentence is underlined. And the emphasis is given, or the inference is given, that this is a procedure, it terminates, and the shield is lifted. That's not correct. It's not correct in principle, and it's not correct on the basis of this judgment, because the next sentence is, 4, it is implicit in that rejection that the claimant does not meet the definition of a refugee. In other words, they do not have a well-founded fear of persecution for a convention reason as envisaged in that convention. So what the court is saying here, and it is the correct reasoning, the correct approach, is that the shield of refoulement applies for so long as you need it. What happens when you finalize most asylum applications is you're found not to need that shield. It's not that you've reached the end of the process and whatever happens after that falls upon your head. It is that you do not need protection. You have had your facts, you have had your case properly assessed, brought to finality with the rights under the Act, and if need be by a court. And you've been found not to have a well-founded fear. So you can be sent back, you do not need protection. But for some, obviously, the world will change and new cases will arise. In this regard, my colleague has submitted that there is no right to reapply, and there's an emphasis on that. Where, he asks, in the Act can we see the right to reapply? And our submission is a simple one. There is no explicit mentioning about how many times you can apply for asylum, because it's a fundamental, substantive human right. It's a protective right. There's nothing in our Constitution about how many times you can rely on any of the human rights in the Bill of Rights, because you hold them forever and you exercise them when you need them. So, too, here. And that is the only way, with respect, to understand the true meaning and the true content of the right of non-refoulement. And once one understands that, this idea that there is simply a procedural perspective to non-refoulement falls away. And I would just briefly like to quote two of the judgments of this court which say that non-refoulement is more than procedural. The first is in Ruta at paragraph 28. I'm not going to ask the court to turn to it, it's quite brief. The court simply says, the right to seek and enjoy asylum means more than merely a procedural right to lodge an application for asylum, although this is a necessary component on it. And it goes out to set out the further importance of non-refoulement, and that's shortly after that famous paragraph where the court emphasizes how this right flows from international human rights law. The second is in this court's judgment in Saidi, the Saidi judgment, and I would quote from paragraph 27. And this court said, this court has repeatedly emphasized that courts must adopt a purposive reading of statutory provisions. One of the purposes of the Refugees Act is to give effect within the Republic of South Africa to the relevant international legal instruments, principles and standards. At the heart of the international refugee law is the principle of non-refoulement, non-return. This, and this is what I emphasize, this is not about non-return for the sake of it. It is about not returning asylum seekers to the very ills recognized as bases for seeking asylum that were the reason for their escape from their countries of origin. Is it focused on why are we not sending them back? Because they cannot face those hardships in their countries of origin. And so already, and on that basic assessment, we submit that the applicant's case, the department's case must fail. To turn to the second point then, about surplus applications. There has been, by my learned colleague, definitions given to the court, and they appear in his head and I believe in mine too, about what a surplus application is. It is an application made by someone who was in this country at the time that their claim to refugee status arose. And there are various ways to phrase it, and there are variations, but they don't particularly matter for the purpose of this case. That is conceptually distinct from a person who's applying again. You could be a surplus applicant the first time you do it. You don't have to be a repeat applicant. And in principle, you could apply again without being a surplus applicant. You could do what the respondents told my clients to do. Return to your country of origin, suffer again, and then come back and make a repeat application. But in practice, these two concepts do overlap. Obviously, many times when the world changes and you have been in South Africa for years awaiting a final outcome to your application, it may well be that you then have to make a second application based on the new facts. And that would make you, as my clients are, both a surplus applicant and a re-applicant. And the confusion appears to have risen not on my client's side or in our papers, but on the respondents' slightly shifting stances in this matter. It bears emphasis that in this matter, the decision which ignited this litigation can be found in the core bundle, volume 1, at page 44 of the core bundle, volume 1. This was the email from the Director of Asylum Seeker Management in the Department of Home Affairs, directed to then my client's attorney, saying a failed asylum seeker who has not departed the Republic after she was rejected must be deported. That's my instruction to the officials, and I'm waiting their update. Those who return from their countries and wish to apply, they are free to apply. So somewhat peculiarly, the stance of the respondents, so the applicants in this matter, began with them saying we don't accept surplus applicants. You have to go back and return. We do accept re-applications. And this position has, because it is an odd one, appears to have shifted in a confusing way in the respondents' various papers throughout this 7-year saga. And today it appears, with respect, if I understand my colleague's submissions, that he is distancing himself from this position initially adopted by his clients. And he is relying on a pure argument of law, that there is no right to reapply. Well, whatever their argument, our submission is the order of the SCA is a good one, because whether they are surplus applicants or whether they are re-applicants, they can reapply. And that is the right, that is the order they should have been given, and that is the order that they got from the SCA, and that should be upheld. Turning to the third topic then, the question of, is there a clear right? Our submission is that the Act, properly interpreted, explicitly and clearly and reasonably provides for reapplications. And perhaps just to do that, we will begin from how an application would proceed. And we'll start at section 21 of the Refugees Act. 21 sub 1 sub B says, an application for asylum must be made in person in accordance with the prescribed procedures to a refugee status determination officer at any refugee reception office. So that's how you initiate it. You go to the refugee reception office and you appear before a particular official, the RSDO, the Refugee Status Determination Officer. If one moves forward, one would look at section 22, which is the asylum seeker visa provision. That, and I would refer again to subsection 1, an asylum seeker whose application, in terms of section 21.1, has not been adjudicated is entitled to be issued with an asylum seeker visa in the prescribed form. So a person applies, they get given their section 22 for so long as they are applying, but then sooner or later they must face an adjudication of their claim, and that occurs under section 24, decision regarding application for asylum. And what one sees is that the RSDO at subsection 3 will assess the merits of that claim and can make 3 possible decisions. One, under subsection 3A, is to grant asylum, and the third one is to reject the application as unfounded. But there is another option under B, to reject the application as manifestly unfounded, abusive, or fraudulent. And unsurprisingly, my emphasis will be on that word abusive. Because what that means is that the RSDO will have to look at this application and will have to, has been granted a duty to assess it and ask himself or herself, is it abusive? And to do that, the first place they'll look is, what is an abusive application? And that is where, in this process, you see the definition of abusive application come up. And of course, it states that in subsection B of that definition, that an abusive application is one made after the refusal of one or more prior applications without any substantial change having occurred in the applicant's personal circumstances or in the situation in his or her country of origin. Now, my learned colleague has submitted that definitions don't create processes. And instead, they define what is acceptable and what is not. And this is no more than a prohibition. And perhaps partly that chain of logic has some sort of theoretical sense behind it, but applied to these facts, it is unhelpful to the applicants. Because what is held to be abusive? It's not all reapplications. It is very clearly, very explicitly, only reapplications that have been made without any substantial change. And that is the only, with respect, way to read this interpretive clause. So therefore, it's clear that the system in the Act has officials vested with powers to assess applications, and in doing so, one of the things that they must ask is whether there's been a change in circumstances. And if there is such a change, then it's not abusive. Then all of the concerns my learned colleague has raised about guardrail functions and about prohibitory sections fall away, because this would not be abusive. It is not abusive to say new facts have arisen. You've never considered the developments in Palestine, in the Ukraine, in Tanzania. Pick your poison. There was a alleged coup d'etat in Madagascar less than a month ago. That has never been considered, and I now ask you to do so. And when that happens, in order to make sure that the right of non-refoulement is not breached, one goes through the process again and one enters into that assessment of those new facts. If you cannot show that there's a substantial change, then you get blocked at the door. Your application is abusive, and that prevents you from going any further into towards attaining the right to refugee status. I would also draw attention then, while we're looking at this, to the other provisions of the Act. Justice Rogers mentioned sections 3, 4, and 5. 3 is the definition of who qualifies for refugee status, and it bears mention there that there is no suggestion that in order to qualify for refugee status, that you need to have not had a prior application. That you do not see here. nor one perhaps even more tellingly do you see it under Section 4, which is exclusion from refugee status, people who are not permitted to get refugee status notwithstanding the merits of their claim. And perhaps also Section 5, which is persons who used to qualify for refugee status, but their claim has, for whatever reason, ceased. None of those sections provide for it. What my colleague does point the court to is Section 21.4 and Section 24.5. I must say that I can see nothing in Section 21.4 which concerns this matter one way or the other. It certainly does not seem to be infringed by the notion of reapplications. It simply sets out an entirely different right, which is that if you are within the process of applying for asylum, you may not have proceedings instituted or continued against you. Section 24.5, we would make a point with respect again made by Justice Rogers, which is that Section 24.5 says that once you end your process and you've been rejected by the RSTO and had it confirmed by the Standing Committee, you must be dealt with as an illegal foreigner. And our point is that then you have the rights of an illegal foreigner. And the rights of an illegal foreigner include the right to apply for asylum. That is the well-established binding jurisprudence of this court and indeed of many other courts who have followed in this court's wake. So it is simply, there's no conflict here. There is no difficulty with reading this act in a way that gives effect to those fundamental principles of non-refoulement that I submitted to the court earlier. If one bends over backwards and says, well, maybe this act is silent, perhaps we look at it and we wish this act could have been a bit more explicit about certain things, which incidentally is the high point I would say that the amicus is. The amicus does not say there's no right to reapply. At best, the amicus is saying that there could be a little more detail given in these procedures. But there could be, but there doesn't need to be, because the process here is a clear one. It follows the ordinary steps. It can be carried out by the ordinary officials. It requires, aside from the assessment of whether there's been a change in circumstances, the ordinary exercise of powers by persons who already exist within the department. There is no significant tension or inconsistency within this interpretation of the Act. Thus, having said that, and if that submission is correct, then many of the concerns raised by my learned colleague fall away. There was a concern we didn't raise a constitutional challenge. It's correct, we didn't. Because in our interpretation of this Act, we don't need to. And had we done so, and we had arrived before this court, I think the court would have said to us, do we need to strike down any part of this section, of this Act? Or can we simply interpret it to give you the relief that you seek in a way that accords with international human rights on the Constitution? And the answer is yes, you can. Therefore, my colleagues' concerns about a mandamus fall away. A mandamus is warranted where there is a clear right. We submit there is a clear right. That is the total and complete answer we submit on that question. The fourth point then, Justices, to which I wish to turn, is the concern about, I would call it the floodgates argument, or perhaps the never-ending cycle argument. This is the concern raised that if this court allows reapplications, that this will permit persons to bring an infinite cycle of asylum applications, and therefore there's going to be some kind of insuperable burden upon the asylum system. Well, to begin with, my colleague has also stressed this is a question before this court of law. If there are practical difficulties which do arise in the future, and I am going to address them, but let's just state up front, looking at the clear wording of the definition of abusive application, at the system set up here, at the way that there's no indication in any provision of any act that you cannot bring a reapplication, this is what the statute says. And if it needs to be changed, it is for Parliament to do so. If Parliament encounters, in the wake of this court's decision, that there needs to be some variation, it can and it will do so. I would wish to point out that in the course of this litigation, this case was launched in 2018, I believe, there were significant amendments to the Refugees Act. They did not affect the provisions to which we rely upon. the key ones, the definition of abusive application, the right of non-refoulement. Parliament did amend this act. They did not see fit to change this. And if in future they need to, they can. But that is Parliament's duty. It is not this court's duty. This court's duty is simply to look at this act and interpret it in light of the Constitution and international law. But the fear of an endless wave or never-ending cycle is, with respect, factually unfounded and unwarranted. And let's just begin with certain facts put forward by the applicants on their own papers. If the court turns to the core bundle at page 104, what the court will see at page 104, volume 1 of the core bundle, is part of the answering affidavit filed by Mr. Madumisa, one of the now applicants. And there's some details there about the applications brought before the department. In paragraph 94.1, there's an itemization of how many applications the asylum system receives annually, from 2008 all the way to 2019. What one sees there is a radical decline in the number of asylum applications. The most likely explanation being that what you saw in 2008 was a spike resulting from the electoral violence in Zimbabwe. So there is something of a stereotype or a trope that our asylum system is overburdened, that hundreds of thousands flee to our country, that our systems cannot handle this. And make no mistake, the asylum system has many problems, and they could do with more resources. But they are not overwhelmed with asylum seekers. There is a significant decline in the number of persons coming to apply to this country. And then the second subparagraph there, 94.2, I just want to emphasize the nature of the backlog. So it's well known that the refugee system does take a long time to finalize matters. But what you see there in that second line there is that there are cases, there's 5,584 cases pending before RSTOs, those are the initial decision makers. There's 41,471 cases before the Standing Committee, the SCRA. And then there's 336,814 cases before the RAB, which is now the RASA, the Refugee Appeal Authority. The point I make from this is that the backlog exists primarily at what is now the RASA, the Refugee Appeal Board. That's because of the way that they make decisions. They have hearings, they operate almost like a quasi-court, and that is an onerous procedure. In our replying affidavit before this court, there is even a report from the officials at the RAB indicating that because of the constraints upon them at that time, they could only decide 215 applications per year. And they list the various problems that they have. Short-term contracts, difficulty contacting persons, a range of difficulties. Why does this matter? Because it matters because there isn't a big backlog with the RSTOs. There isn't a big backlog with the Standing Committee. And those are the officials who are going to face the supposed influx of persons if this court decides in my client's favor. So they are there, they are ready to handle this matter, they are certainly competent and empowered to do so, and they have the capacity to do so. But let us go further. Let's say that I am wrong with respect, and that there are going to be, let's call them the genuinely bad faith actors, the persons for whom nothing good can be said, and their purpose here is to abuse our asylum system. Could they do so under the interpretation advanced by my clients? Well, we would submit their constraints even upon them. The first is that if they do this, if they wish to abuse the asylum system, there's really only one reason they would do so. They do so because being in the asylum system affords them a Section 22 visa for an extended period of time. That has an easy and obvious fix. Expedite the applications, the reapplications. If someone files a second application, we fully support the Department of Home Affairs saying, we are going to give you your decision in a week. And we think the department should do that. There's nothing, that is a matter of practice, it's not a question of law, it is open to the department to do so. That simple mechanism removes any motive that a person might have to abuse the system because they get nothing from it. But if there was further abuse, we turn back to the Refugees Act. because there are already provisions in the Refugees Act that allow for penalties to be imposed upon those who, for whatever reason, are seeking to abuse the asylum system. The Director General, this is at section 22.5. The Director General is empowered, prior to the expiry of an asylum seeker visa, to withdraw such visa on certain limited conditions. And one of those conditions is if the application for asylum has been found to be manifestly unfounded, abusive, or fraudulent. So it would be open, in principle, for the Director General to say, you are reapplying, I have applied my mind to your circumstances, and I think that you are, quite frankly, the worst of the worst. You are a bad faith actor, you have brought this application with no intent to benefit from the true meaning of the refugee provisions, and therefore, I'm taking away your Section 22 visa. And there are further provisions which I can't take the court to because my time is up, but the DG could even go further and could, if necessary, imprison and detain, subject to the control of a court. Those are sections 23 and 29, could even detain such a person. So if this court looks and says, does the Department of Home Affairs have tools to combat this semi-fictional fear of a floodgates? Yes, they do, they exist, and that is a complete answer to that problem. And I gather that is where I'll have to draw the line, Deputy Chief Justice.
Thank you, Mr. Simmons. Do I understand you to be saying, saying the potential for abuse of the system by allowing repeat applications is not there?
Not in any well-founded manner. One can posit a theoretical possibility. But even that theoretical possibility is such an extreme scenario that it is completely outweighed by the consequences if this court were to close the doors of the asylum system. Because when you close them, you leave out the good and the bad. You leave out the Palestinians and the Ukrainians and the Tanzanians and so forth. Those are real examples, real cases, real problems. Proof of this supposed floodgates, we have yet to see it. That is all one can say.
Yeah. Now, you posit all your submissions on the basis that your clients, I think you started by saying they are surplus applicants. Am I correct?
Correct.
But the general drift of your submissions is that the right to make repeat applications is there. Where do you locate it?
It is there. It's not founded in the fundamental idea of a surplus applicant. That is a distinct concept, but it does arise from the Act.
Yeah, I'm talking about the right to make repeat applications. Where do you locate that in the Act?
From a proper understanding of the process, which grants, I would say in section 21, read with the definition of abusive applications. Because what you see there is an explicit empowering of RSTOs to consider what occurs when a repeat application is made. It's very clear, it's explicit, and I've taken the court to it. There is only one possible reason to allow that, and that is because you can make repeat applications. You may not succeed in them. They may be ultimately found to be abusive, but they'll only be found to be abusive if there isn't significant change. If you can show significant change, it isn't abusive, and the application proceeds as normal. If I don't even call it a lacuna, the difficulty arises if this court finds that there isn't such a power, because then that part of the definition is dead and is meaningless. And such an interpretation, it's quite trite, cannot be adopted by a court.
Yeah. I know that we don't have to go deep into the facts of this case, but your clients, are they repeat applicants or are they surplus applicants?
They're both, Deputy Chief Justice. They're repeat applicants in the simple sense that they've filed an application, it ended, and now they're filing another. They're surplus applicants in that they were in South Africa when the claim on which they seek to rely on the second time around arose. Because that claim arose in 2015. That was when the events in Burundi broke out, and they were in South Africa in 2015. while one could, if one wished to dive deep into the concept of surplus applicants and the variations in it, that is the core and that is sufficient for this matter.
Thank you.
Mr. Simmons, let's debate finality for a moment, because that's one of my areas of concern. If a surplus refugees application is refused, do they have the right to apply on several occasions for as long as they say that the situation in their country has not changed?
Let me check if I heard that correctly. Would a surplus applicant be able to reapply on the same facts?
Yes.
No. Well, they would be able to reapply in the sense that they could place their application before an RSDO. An RSDO would then cut it off and say this is abusive. And then if they're necessary, the Director General could say, well, even if this goes on to the Standing Committee, I won't give you a Section 22 visa. So the system is effectively closed by the RSDO to such kinds of applications.
Okay. Firstly, if they state other facts, not the same facts, in the first application, do they have a right to be considered at least?
They would have to show that it's a significant change, is the wording of this thing. And the exact meaning of that would be quite context specific. And one can venture into it, but that will probably be developed by future cases.
And that right would remain fourth, fifth time and all of that, as long as they change the story.
As long as it changes, as long as it changes.
And my other concern is that when the application is being considered, it doesn't take just one day. It takes time, and all that time, the person remains in the country, comes up with a new story, but he's got a right, you say.
The person would remain in the country because we couldn't send them home, but the person would not necessarily have a right to the Section 22 visa, and the person would not necessarily even be free. It is possible for detention to be imposed upon persons if they've been found to have acted abusively. That's under Section 23 or Section 29 of the Act. And so it is a theoretical possibility that someone will be so determined to stay in this country that they will stay in our prisons. But with respect, it is little more than a theoretical possibility, whereas the real problems of the Palestinians and the Ukrainians and so on are far more pressing.
Well, you've argued that the answer lies in Section 1, the definition section, and you said that the reference to applications, to reapplications, should be read as allowing several applications. I've heard that. But where do we get the cutoff point in the statute itself? Does it say how many times?
It doesn't say how many times, Justice. The cutoff point, there's deliberately no cutoff point, because the refugee system is deliberately an open one. What you can't necessarily get are the benefits of the system. You can't necessarily get the visas, and you certainly can't get the refugee status, because you'll be found to be abusive. So the concerns about people being drawn in floodgates will end if the act is properly applied. By properly applied, I mean speedily decided. I accept it might not be one day, but you can expedite RSDO decisions. There isn't even much of a backlog. You can deal with it in a matter of a couple of weeks. And with respect, no sane person is going to go through our asylum system to be afforded no visa for a few weeks, and they're subject to the risk of detention. Although if I may briefly on detention just emphasize, this court's rulings hold a great deal of weight, and the court perhaps should be caveat any suggestion that those powers should be exercised lightly when it comes to detention or stripping of visas. It is possible to do so. It is sometimes necessary to do so. But Section 22 visas are fundamental to a dignified life in South Africa, and it should be an exercise of power only against truly bad faith actors, not as a default consequence of making a repeat application.
Well, my concern stemmed from having read Ruta and Abore. There seems to be the undertones from the evidence led in those cases that most people stay in the country untraceable. Some people stay in the country, enter the country illegally, and only indicate an intention to apply when they are arrested. And this is where my concern arises. And several occasions as well, you talking about detention and refusal of a visa, but my worry is when they attract, then those measures would be enforced. But let's move on. At least you know where my anxiety comes from. Apart from the definition section, the 1951 Convention and the 1987 Protocol, do they deal at all with reapplications or the situation of surplus refugees?
No, not in explicit terms, Justice. There is the almost penumbra of soft law that the amicus has touched upon, the UNHCR provisions that talk about these aspects and the appropriate way to handle reapplications. But I wouldn't point to an explicit reapplication provision. The convention deals with non-refoulement in a similar way that you would deal with any underlying value or right. It says we protect non-refoulement. And in fact, our act goes in some ways even further than the convention does. But we rely also upon the African Convention and other international conventions.
Okay, thanks. Maybe you responded, but I didn't hear you responding to the submission that you should have made a frontal challenge, frontal attack.
Our answer would be that we don't need to, because a frontal attack is only necessary if this act cannot be interpreted to grant my clients the rights that they seek. As it can, and indeed we would submit it must be interpreted in that way, a constitutional challenge is neither necessary nor would it be successful. It would have failed, because this court would have said, we don't need to strike down this act, we can simply interpret it in a constitutional fashion.
By reference to the definition section.
By definition, the definition section, and to go further again to section 2. Section 2 is not a definitional section, but it is because of how it's phrased, that it applies notwithstanding any other provision. The rest of the act must be read to give effect to section 2. And again, there is no way to read this act to give effect to section 2 concretely unless you allow reapplications. Because if you don't, then you will face, we'll call it the Palestinian problem, that people will have made applications, the facts will have changed, genocide will be occurring in their countries of origin, and they would be sent back to face those hardships, and that is clearly a violation of section 2, and therefore you cannot read or interpret the act in a manner that would create such an outcome.
Okay. On the issue of the stages of the application, at what stage did first respondent end his application? Did he go to the appeal board?
They went to the Standing Committee for Refugee Affairs. So it was finalized by the Standing Committee.
Okay.
Both of the current respondents did so, and I should note that the process by which that happens is automatic. So every person who's found to have a manifestly unfounded, abusive or fraudulent application will automatically be considered by the Standing Committee for Refugee Affairs.
I lost you when you were talking about the clear right. Where do we source the clear right?
Well, that goes back to the definition of abusive application and section 2 of the Act read in the full context of the Act as a whole. Because clearly the Act contemplates the ability to make reapplications. That's why it empowers officials like RSDOs to consider them and decide whether there's a change in circumstances or not. On the reading of my learned colleague, it's almost as though what RSDOs do is they consider if you've made one prior application and then you can't do any more, that's abusive. But that's not the definition. Very clearly the definition is it's only abusive, not if you've made a reapplication, but if such reapplication is the same as your previous application. That's abusive. And in granting RSDOs that power, imposing on them indeed that duty that they must look at applications and consider that clearly creates a pathway for repeat applications that only makes sense if you can make repeat applications.
Can I ask you whether this is what you submitting we should do or not? Could be. I'm not. I have not captured you properly. Should we say when we are dealing with a right that is not specifically dealt with in a statute, we take into account what the definition refers to as a possibility? Because in that definition section, it doesn't say that this is the right, you've got the right to do this. It simply refers to applications. So I'm saying that should we then conclude that if a right has not been specifically dealt with in a statute, we go to the definition section and look at what the possibilities that definition section is covering.
Yes, Justice Cheeky, one can and should do that. And of course, the interpretation of any provision or any right or any power flowing from an act is a holistic enterprise under the well-known case law about interpretation. So the court will look at a range of things. It'll look at the definition section, it'll look at section 2, it'll look at international law and the soft law instruments that the amicus has put forward, all of those factors. And every single one of them indicates you should make repeat applications. Even to pause and note that my learned colleagues' heads refer to a great deal of foreign law. And what I would submit is striking about that is it's very evident that all of the countries of which we know do allow repeat applications. So this notion that you can make a repeat application is the norm. It is what is necessary. And what we have to do is look at our act and say, do we have the same? And we do.
And what do you say to the submission by the applicant that in those other countries, it is specifically provided for the legislation in a clear matter?
We would submit that it is quite clearly provided for. I mean, I admit perhaps it could have been clearer. It could have been a separate section. It could have said one can make unlimited reapplications. One can always take a statute, and lawyers can say this could be clearer. That is inevitable. But to look at this, the way that it is granted explicit powers to say, is this application different from a prior application? And it is given those powers to the person, the RSTO, who considers asylum applications. That's clear. That process is clear. And so it is as explicit as it needs to be. And even with respect, even if it wasn't, let's say the act was silent, and the court had to consider an interpretation of the act, one of which allows Palestinians to go back to Gaza and one of which does not. With respect, there is simply no contest between those interpretations, not under the Constitution or international law, Section 2, or any of those provisions.
Thank you, Mr. Simons. Thank you, Mr.
Thank you, Mr. Simons. I just want to get some clarity from you. If you're urging us to confirm that the Act creates a right to reapply, and that's your argument, not so. How would we frame that right? Would we say, because we would need to frame what that right exactly means, so that there's certainty and clarity with regard to what is the scope of the right in question that we say emerges from a proper interpretation of the Act.
Justice Colopin, I would say that it wouldn't be quite right to sort of a right to reply as though it's a self-standing thing. It is an adjunct to the right of non-refoulement. It is a necessary component of that right, which this court has already defined and elaborated upon a great deal. And all that this court needs to say in its reasoning and logic would be that in order to give effect to non-refoulement, a person must be able to reapply because circumstances change, and that's it. In terms of the order, we would be satisfied with the order granted by the Supreme Court of Appeal.
So that would be a right to reapply in the widest terms, and that would be a right without any restriction, correct? In terms of the number of times, etc., because it would be a right, according to you, that would fit comfortably within the current structure of the Act. And secondly, the procedures by which one gives effect to the right are already provided for and catered for in the Act. They should simply apply. So there's no need to do anything beyond that. Correct?
That would be our submission, Justice Colleton.
So can I just go back to your argument that what we're dealing with here is not uniquely South African, that it has an international perspective and has authority both in particular jurisdictions, but also at the level of the United Nations for how, what I'll call now repeat applications or subsequent applications. You may say it encompasses surplus applications, but for now let's use that language. Would you accept that certainly at the international level, repeat applications and first-time applications are dealt with quite differently conceptually? Because as you point out in paragraph 43 of your heads, you say that it has emerged as a concern in many national systems. And it goes to the fairness and integrity of those systems as well, not so. You refer to the UNHCR guide to effective processing of asylum applications. So the question of how those systems are constructed goes to the integrity of those systems, and it goes to questions of fairness. And understandably, when one is dealing with repeat applications, we don't start with the default position that they're bad, but we're entitled to start with the position that they've been adjudicated before, same claimant, probably the same country of origin, maybe different circumstances, but there has been an adjudication and a full process. Certainly in our context, it would be 3 or 4 internal processes. It would be right of review coming right up to this court if they can engage our jurisdiction, so it would be a full process. And therefore, there would be a justification in dealing with repeat applications differently. And that's what emerges certainly from the UNHCR, so much so that if one does an overview of even the jurisdictions the SCA relied upon, in Canada, doesn't allow a subsequent application. Other countries have different procedures, for example, that it may be kicked out at first base, for example. You may not even be entitled to a hearing or a full ventilation of your application could be knocked out at first base. So I'm just saying that the concept of a repeat application is not identical and should not be identical to that of a first-time application. And that's what emerges certainly from the foreign law as well as the UNHCR.
In short, I would agree, Justice Colopin. I would say when you put to me, are there differences? Well, there may be differences, and it depends on what those differences are. Some things remain the same. I mean, the purpose remains. The question, is there a well-founded fear of persecution? The way in which the hearing is conducted, the officials concerned, there may be a great deal of similarities. We do accept that repeat applications, there will be some differences, because you have to have, or you should have, that sense of differentiating yourself from the first application. And it is that differentiation that the person must show to overcome the difficulties that one would otherwise face about overturning prior decisions and so on.
Okay. But you're saying that we should interpret the Act to both create a right to apply and for the right to be given effect to in accordance with existing procedures. That's what you said in response to my initial question. What would emerge then, if we're with you, is that there would be absolutely no difference in how a first application or a repeat application is treated. And let me explain, because the section that deals with abusive applications is sort of coupled together with applications that are manifestly unfounded and fraudulent applications. And the RSDO has the same powers in respect of all 3 categories of applications, not so. The right to refuse a Section 22, to withdraw it, would apply even to a first-time applicant, not so. And the right to seek the detention of an asylum seeker would also apply to a first-time applicant. Correct. So, apart from the language in 1B that speaks to prior applications, Would you agree there's nothing in the language of the Act that speaks to a different system of processing at the very least? Because you've argued that if we uphold the SCA order, the processing will be done in accordance with the Act as is, including the right to a hearing, all of the safeguards, and important safeguards they are. But we don't have a separate system, correct?
It's different in the sense that there is that a higher hurdle and different hurdles set out by the definition of abuse of application. But in many senses, yes, I accept it would be the same. It would be decided by the RSDO. The RSDO would be the one assessing it under the usual standards, except for the applicant must show what's changed in their circumstances. And that is a sufficient difference. Perhaps I'm not sure this answers your question, but that is the key difference, in fact. Why should you be allowed to apply again? What has changed from the past? If you cannot show that, then you should not be allowed to apply again. But if you can show that, if you could say, take again a good faith person who can say, something completely unexpected has happened. There's been a coup d'etat. It's a whole new set of facts. Then that person should go through the same process. They will face on that new set of facts. Yes, they'll have the same rights, the same processes, the same duties and so forth.
But you're saying they should show why they should be allowed to apply. But in the current reading of the Act, there's no question that they are not allowed to apply. Everybody's allowed to apply. It goes through a system, not so. There isn't a guillotining that says, well, you can't, as opposed to systems that may exist in other countries that would say, well, at the entry point, we're going to say no, subject to your right of reviewing that decision only. But we won't even consider your application in the sense that we would consider. But in our system, you're in. Whether you're abusive, whether you're fraudulent, whether you're manifestly unfound, no one can stop your application from being submitted, and you have a right to insist that my application be considered, albeit that you can reject it on the basis that it's manifestly unfounded, abusive. But you're in the system, not so.
Justice Colopin, I think perhaps the distinction here is on what we mean by apply. I accept that in our system, you can place an application before an RSDO. Anyone can do that. But with respect, that is the same in the systems that you'll see covered by the amicus and by my learned colleague. They too allow you to put that in. It's just it's the question of where is the screen. Now in our system, the screen is with the RSDO. Now that is a very sensible place to have the screen. The RSDO is a very competent official versed in the facts of the previous matter and all that. And therefore, the RSDO will first do the screening. Will say, do you get over the burden of whether this is abusive or not? And then if they pass that, the RSDO will look at the merits. Now, in other systems, it may, and it is possible that you could separate them. You could have a different official do screening, and you could have a second official do merits. But that difference is one of form, not substance.
Except in our case, the RSDO must undertake the same fair processes that such a person would have to undertake in respect of the first application. The hearing,
the fair processes,
all
yes.
of those safeguards exist.
Yes.
So the point I simply make is that it seems difficult to suggest that the inclusion of language in the definition without anything expressly including or excluding second-time applications then lends itself to the conclusion that a proper interpretation of the Act, notwithstanding what we know about how the UNHCR has approached it and other countries, which the SCA relied on considerably, must mean that there's a right, unfettered right to a second application that would function on the same basis as a first application. Would that not be, because what we're really saying is that Parliament must have had in mind second applications, and if they did, this is how it will work. You have a right, and it will function exactly the way in which your first application does. That's the conclusion that this court would have to come to.
Well, exactly apart from the higher burdens and the separate inquiries imposed by proper understanding of the Act. So This is why I don't mean to dodge your question, but there are differences between a repeat applicant and a first applicant. Those differences are appropriate differences. It's just that they don't, in the way that the applicants have it, they don't close the door to all reapplicants. They close the door to abusive applicants, and abusive only means those who have not shown a difference in fact. And it may be, yes, that you can go in and you can file your application with an RSDO, and then just get rejected over and over and over. But the reason that you might do that is because you seek to gain some benefit. That's the only theoretical possibility that there might be. And that is easily remedied by expediting outcomes, by not granting Section 22 visas, and in the most extreme of circumstances, and indeed we hope not to see this ever because it is a deprivation of liberty, but deprivation of liberty under Section 23.
I just want us to be clear that, abusive applications don't stand on their own within the structure of the Act. They dealt with, together with manifestly unfounded and fraudulent. So the same power is attached. So from the legislature's point of view, it dealt with all three categories of applications as having the same potential consequence and effect from the perspective of the RSDO, from the perspective of the permit, etc. Okay, I'll leave it there.
Correct, Justice. I accept that.
Mr. Simons, just on this issue of the appeal, which I raised with your colleague, Mr. Ramachale, Section 24B allows for an appeal, and if there's new evidence for the matter or the new facts, that it can be referred back to the RSDO. Is there not administrative sense in keeping the appeal system alive and in requiring applicants for asylum to, if new facts come to light, bringing an appeal and then having the matter referred back to stop this, the potential that there would just be a repeat application process emerge?
I'll answer that, but on appeals generally, just to give some background, the asylum system operates with a split structure. When it goes before the RSDO and you get an initial decision, if it is found to be unfounded, then you can appeal. You don't have a right to, but you can file an appeal, and that's Section 24 capital B. But almost all of these cases would not go that route. There would be no appeal in that sense, because what would happen is that you would be found to be abusive, or at least you would be falling under that heading, and then if you're found to be abusive, then you go to the Standing Committee on automatic review. And under the automatic review, you don't get a hearing and all of those.
Why would the applicants in the, for reconsideration in this case not include your clients? I mean, if new evidence came to light, there were new facts that needed to be placed before an RSDO, why could that not be the subject of an appeal? Does that not fall squarely within Section 24B5?
It would have to take my clients as an example. They were found to have manifestly unfounded cases. Therefore, they don't have a right of appeal, because you only have a right to appeal if you receive a decision that is unfounded. So perhaps if I could ask the court just to clarify this, to look at Section 24 sub 3 again.
So you're saying because they were under B, manifestly unfounded, abusive or fraudulent, they then couldn't appeal, they could only appeal if they were rejected as unfounded?
Correct.
Inclusion of the word manifestly.
Yes, and if you look at Section 24 capital A,
Yes.
it says the Standing Committee must review any decision taken by an RSDO in terms of Section 24.3b, whereas Section 24 capital B, the RASA, that is any asylum seeker whose application has been rejected in terms of Section 24.3c may lodge an appeal.
So then, as I understand you, the review before the Standing Committee is what would be the remedy in terms of a non-repeat application. I'm just looking for a remedy short of a repeat application.
Well, if it happened that the change in circumstances occurred between your RSDO decision and your SCRA hearing, I suppose one could write into the Standing Committee and seek to make further submissions and say, when you're considering this matter on your automatic powers of review, we seek to place this further evidence before you. I haven't looked deeply into that point, to be frank, Justice Savage, but I don't see a direct problem with that. But the problem is, of course, that almost everyone who's going to be affected by this will already have received their Standing Committee decision. And that decision will stand. What will have happened in truth and in law and all those things is that the old claim was a bad one, and now they have a self-standing, different new claim. And the appropriate thing to do is to have that vetted as a new claim from the beginning.
What would stop the abuse, though, from an administrative, not necessarily in relation to your clients, but relation to every applicant who's been unsuccessful? What's going to stop you say it's not going to occur, but what is going to stop every unsuccessful applicant for asylum not simply reapplying?
Well, because they would get nothing from it.
But it would at least cause a significant delay.
But our submission would be that they don't endlessly appeal to cause Home Affairs problems. They, in theory, and I don't know, but in theory they would be endlessly appealing because they would get a benefit. And the theoretical benefit is a Section 22 visa which persists for years, because that tends to be with first applications, that's what you get. And the remedy to that problem, there are both legal and practical remedies to them. The practical one is to expedite these applications. They can do that. As we've mentioned, the backlog is at the RAB. RSDOs and SCRA can expedite these matters, and then you get no benefit from reapplying. But secondly, if you did have someone who, for whatever reason, was hell-bent on abusing the system, quite frankly, then you find them to be abusive, you deprive them of their Section 22 visa, you could even detain them. And that is, the detention is the most severe sanction we have. One can give no better answer under South African law. How do we stop people from doing things? That's how we stop them.
Thank you.
Mr. Simons, just one clarification from me. What was the basis for rejecting your client's application?
Unfortunately, Justice Matopo, the Standing Committee does not give reasons. They simply confirm the decision of the underlying RSDO. So as to their reasons, I cannot say. It appears from my client's testimony that, frankly, the processes they were subjected to when they initially applied were extremely flawed. Lack of interpretation, lack of understanding of the processes, the copying down of false or incorrect or inaccurate or incomplete information. So, quite frankly, they perhaps should have, but the system found otherwise.
Do we now know whether their application based on new facts was actually considered or not, or we just in the dark?
They've never been allowed to file the new application for the new facts. They will only be allowed to do so if this court upholds the SCA's order.
Well, currently, as the issue stands, we cannot say that it was rejected on the basis that it was manifestly unfounded and nor abusive.
The first application was rejected because it was manifestly unfounded.
The first?
The first. And there has yet to be a second for my clients.
So when the second application was launched, it was based on what your client says were new facts, changed circumstances, and those change or new facts were not considered by the department, or were they considered?
They were not considered, and to be clear, they were not even lodged. My clients did not appear before an RSDO, they did not get issued with Section 22 visas, at least not as a consequence of filing their application. They were told, you cannot apply because you have not returned to your countries of origin. And we will only let you reapply to get your foot in the door, as it were, once you return from your country of origin, which we said was impossible, and now we are here.
Well, that would work hardship if one were to take into account the situation that is prevailing in Tanzania, Gaza, and I don't know what was the situation in Burundi then, which prevented your clients to go back. But if the situation as we know it now, in Gaza and in Palestine, Gaza and Burundi, I mean, it's like from the frying pan into the fire. And correct me if I'm wrong, the reason why the principle of non-refoulement is adhered to and applied is to deal with such exigencies.
Correct.
Now, if you throw the baby out with the water, and then what happens?
Incredible hardship, Justice Matopo. That is the difficulty, as we understand it, for the applicants. Because there are, one talks of perhaps a floodgates opening. In that flood, many of them may need help. They are the deserving. Not because the world is a harsh place. And if Tanzania goes a bad way, there will be many who will need to be able to access this system. And there is only one path, and that is through this court, and this court upholding my client's case, not the applicant's.
Well, on the debate you had with my colleagues about the source of the power, which would entitle or give your clients the right to apply, you have said we should look at the definition. I have looked at the definition, but I don't, the first definition in section 1, I see it deals with abusive application for asylum. And we don't know whether it was rejected on the basis that it was an abusive application, or was it a fact?
Just I think where I can credit is, so the first application was rejected because it was manifestly unfounded, and this abusive application definition didn't come into play for the first.
It did not.
Not to my knowledge.
Okay, let's accept.
I mean, yeah.
Let's accept for a moment that the abusive application scenario did not come into. It was rejected on the basis that it may have been manifestly unfounded, and manifestly unfounded would be based on the facts that existed then and the facts that may have been disclosed in your papers. There does not seem to have been any reasonable apprehension of fear or stuff like that in your country. In other words, basically it says you are lying.
Correct. In this case, what seems to perhaps have happened is that my client's facts were not recorded, and they were recorded as saying we came here to study and things like that. And then, of course, they were found to have failed, to have manifestly unfounded claims. There were suggestions in what was recorded in the documentation that that was why they were there. But they didn't complete those forms. That isn't why they came to this country, and it wasn't a true reflection of their facts. But
there's a suggestion from your client's papers that there may have been some language barriers when
correct.
When everything was concluded or was.
Yes. Okay.
But then what do we do? Because I'm just in the conundrum. I just don't understand. What do we do with the position of your clients here?
Well, because of what occurred in Burundi, a new avenue opened up to my clients, which is to file a repeat application. And they sought to exercise their rights to access that avenue. So they were rejected in 2014. That's when the Standing Committee made its decision. In 2015, there was, on their version, collapse, a violent disorder in Burundi. That gave them, those facts had never been considered by the Standing Committee. So this is a fresh set of facts, a fresh claim to asylum. They sought to exercise their right to place that before the RSDO. The respondents said no, and we submit that was unlawful of them. And my clients should have been allowed to at least have the RSDO look at their application.
Basically, that's all that they're asking to say. Give us an opportunity to look at our application anew.
Yeah.
And we are saying in the application there is a departure from the previous application which was declined. We say now the situation in our country has some ramification which precludes us from going there. Would that be the reason why you say there is an overlap between a reapplicant and a swap place? At what stage do they overlap? And
there is an overlap. I agree with you, Justice Matopo, and it's best just to think of them almost separately. In practice, there's often an overlap. But you are a surplus refugee, to summarize, when you are not in your country of origin when the problems occur, but you are in this case here in South Africa. So suppose a Gazan was in South Africa on the day of 23 October 2023. He would say that on that day, I received a right to apply for asylum because there was suddenly this genocide occurring. He's a refugee surplus. Whether he is a repeat applicant, well, that depends. Has he filed a previous application?
Well, tell me here, help me. If your client had filed that application and shortly thereafter, I'm just quoting it notional, and shortly thereafter there are changed circumstances, was it open to your client to go back to the refugee office to say, subsequent to my application, which is still pending, new facts have come to light, and my country is up in flames. There is no way that I can go back.
Just, Matopo, while acknowledging I haven't looked deeply into this, if you are still awaiting a decision from a decision maker within the refugee system, I would accept that you could place new facts before that decision maker. So if you are awaiting a decision from the standing committee, you could attempt to place such facts before them.
You see, yes. My problem lies in the submission made by Mr. Ramokhale that you can't reapply. I'll put it up to him when he reply, because it causes me some discomfort. Because if you come across, or if circumstances changes in your country of origin, how do you expect me to go back instead of afford me the opportunity to apply?
That is the correct question, Justice Motopo. And with respect to my learned colleague, there is no answer from the applicants. We have heard none.
All right, thanks.
Mr. Simons, just one of the circumstances which at least gives plausibility to a second application based on changed circumstances is the amount of time that elapses after the final rejection of the first application and the bringing of the second. Now, just to take Ms. Irankunda's case as an example, the Standing Committee confirmed the rejection of her claim in May 2012. The UCT Law Clinic took up the cudgels for her in August 2018, more than 6 years later. Now, whether she was still in the country or whether she'd gone back to Burundi and then come back to South Africa because of changed circumstances over 6 years, it is not necessarily surprising that conditions could have materially changed. Do we know, you will remind me, on the facts of this case, why did Ms. Irankuda remain in the country for more than 6 years after the Standing Committee's decision, and why in general, if it is addressed somewhere in the papers, does Home Affairs, whether through its refugee arm or its immigration arm, not deport promptly those people whose cases are finally rejected?
The first applicant does give an answer, but it is a straightforward one. It is that she did not feel that it was safe for her to do so. She, on her version of events, she suffered horrifically in Burundi. She did not, although she had no knowledge of how to challenge the decision against her, she knew what she had gone through, and she did not feel that she was safe to do so.
Right. So in her case, she stayed here knowing of the decision, but feeling it was unjustified, and she wasn't going to go back because it was unsafe for her. That was her state of mind.
In brief.
And do we have any evidence from the department as to why they don't do something promptly? I mean, was Ms. Irankuda hard to find?
There's no evidence
to that effect?
There is no evidence to that effect.
Or is there evidence of a procedure? Because it's similar also in respect of Ms. Nayankuru, also quite a long gap before, slightly less long, but still quite a long gap. Do we have any, because one of the questions that is raised is how do we prevent abusive repeat applications? It seems to me one can't necessarily eliminate all of them, but something that one can do is to ensure that final rejections are promptly actioned by immigration, that those people are promptly deported. Do we have evidence from Home Affairs as to why that doesn't happen?
We don't have any evidence in that regard. And we concur. If you have, yes, if the system is meant to operate in a way that once you've received a final rejection, then at least in principle, immigration authorities should act on it.
Because Home Affairs tells us that once there's a final rejection, which in the case of Ms. Irankuda there was on the 10th of May 2012, the person must be treated in terms of the Immigration Act as an illegal foreigner. Home Affairs didn't treat her like that.
Correct.
It was at least 3 years later on Ms. Irankunda's subsequent application that the conditions deteriorated further or changed for the worse. And she seems to have been allowed to remain at large. Maybe your opponent can consider this, but I'd be interested to know whether this isn't to some extent Home Affairs being the author of their own misfortune by not actioning their final rejections.
I would agree with that assessment, that if you wait a long enough time period, things change. So there is a certain self-inflicted nature of this difficulty. To the best of my knowledge, Justice Rogers, there is no explanation for why that occurred on the papers, but I will leave it to my learned colleague to answer.
Thank you.
Can I follow up on Justice Rogers' debate and yourself? In those circumstances where Justice Rogers is asking, is saying that, well, correctly, in this record, there's no evidence of what Home Affairs did once the application was rejected. If we bear in mind the concept of non-refoulement, what would then have to happen legally if Home Affairs had approached your clients and then they said, well, hang on, we still have an intention to apply again? Because the way I read it, maybe I'm wrong, it says that once a person shows or evinces an intention to apply, then he is protected. So if the decision has been made, and then once the officials approach that person and trace them, then they say, well, we want to reapply, what then would be the situation?
And just to check, Justice Chikiti, is this a situation when there's been 6 years passing and events in Burundi have erupted and my clients have a fresh claim to asylum?
Yes, and Home Affairs, before they make the second application, Home Affairs manages to trace them and want to deport them, but then they say, well, we have an intention to apply. And the law in South Africa says that if we have an intention to apply, the concept of non-refoulement protects us. What would be the situation?
Well, if this had occurred of 2015, yes, they would have said that they want to reapply. They would have then have been taken to an RSTO, and then they could have presented their new facts, which on this version they would have, and they would have been be able to proceed through the asylum system, protected by the ordinary asylum rights. I must make one caveat to that. Subsequent to the 2018 launch of this case, there were amendments to the Refugees Act. Those amendments are not before this court, although they are before this court in another matter. There was a constitutional challenge to them that was upheld in Cape Town, and the matter is coming before this court. And those sections concern, to the extent to which a person can delay in making an application for asylum. So I don't want to get into those, and if we ignore those for the time being, then the answer is yes, my clients could reapply.
Well, your client would reapply, that's fine. And then it is processed, that application, it is processed. And then once it is finalized, your clients wait for about 3 months or so. I know that Justice Rogers said that what's preventing Home Affairs from arresting them immediately. But then let's say that has happened a few days, elapses, before they are pursued by the Home Affairs officials. When they pursue them, let's say on the 10th day, they then say, we have an intention to apply. What then happens then? Are they again afforded another opportunity?
This is now a third application.
Yes. Bearing in mind the principle of non-refoulement.
Then they can say, I wish to apply. And then what will happen is that they will be brought before an RSDO. The RSDO will say, what has changed? Because nothing will have changed in this short period of time, one assumes on this scenario, the application is found to be abusive.
Well, let's say they proffer facts which, according to them, show a change in circumstances. Well, let me not say according to them, but they proffer circumstances where they say the circumstances have changed from when we applied the last time.
Well, it is the task of the RSDO to assess whether they have shown significant change. If they do succeed on whatever these new facts are the third time around, then fine. Then they're not abusing the system, and their application proceeds as normal. If they can't show significant change, this on their third time around, then the application is abusive. The application will fail for that reason, and insofar as it proceeds further to the standing committee, my clients will not be granted the Section 22 visa. Potentially, anyway, it doesn't flow automatically, but the DG could withdraw any Section 22 visa. And if they even wanted to, then yes, they could put my clients in detention, subject to the constraints imposed by Section 29 of the Act.
Okay, thanks, Mr. Simons.
Mr. Simmons, I think in just following up on the debate with Justice Rogers, when their initial applications were rejected as manifestly unfounded, they were notified that they should leave the country within 30 days. Isn't it?
Indeed, sir.
I see. And I'm actually reading from the affidavit of, is it Neo Mpuru? And I think the same sentiment can be found in Ms. Irankunda's affidavit, paragraph 31, where she says, I knew I could never return to Burundi. That's a state of mind.
She says, I knew I could never return to Burundi due to the ongoing political violence and warfare there and due to the traumatic experiences I'd undergone.
Yes. So what are these changed circumstances then? Because that's the state of mind referring to violence, and that's the persecutory environment, isn't it, that they are fleeing from. So in 2017, 2018, what are the changed circumstances? Is it the same situation?
Well, no, Deputy Chief Justice Mlambua, as I understand it, this proceeds in phases.
Yes.
They received the decision in 2014.
Yes.
Why did they not leave in 2014? Because frankly, their belief was that they would never go back to the country where they had suffered. Yes, that founding was not upheld by the Standing Committee. That is what they subjectively felt. So they stayed. And then once they stayed, a year later, or whenever it is, in 2015, then facts changed. And then they had more reasons not to go home on their version. Not only had they the initial reasons on their version, but now there was the collapse of the Burundian political order and the violence and the disorder that had arisen there.
So the changed circumstances were continuing political violence and warfare?
The changed circumstances they would rely on in making their new application, if they're allowed to do so, would have been the events that arose in 2015.
What are those events?
That was
Not what I'm talking about, political violence and warfare.
Yes, the political violence and warfare. That was the violence caused by the attempt of the then president to seek a third term. It is dealt with in the founding affidavit to some extent. I'm going to find if the court turns to page 27 of volume 1 of the core bundle.
Yes, I'm there.
Thank you. The court will see there a lengthy set of descriptions of what occurred in Burundi. In paragraph 99, it's noted that in April 2015, President Nkurunziza announced he'd seek a third term, and that ignited political tensions. And then there's page after page of report from Human Rights Watch and Amnesty International and the United Nations citing immense violence, sexual violence against women, the killing of thousands of people, that hundreds of thousands of people fled from Burundi, that opponents and political opposition were disappeared, were tortured, were abused. That is set out, and if necessary, I will go through it, but...
No, I've seen it.
You've seen it.
I'm just saying, it's the same situation they fled from initially, isn't it?
They would submit otherwise, and this going forward in general will be a debate that RSDOs may have to have. So in Burundi, what happened is they had a severe civil war, and then it ended, and then some years passed. It ended in approximately 2005, and then some years passed, and then a new set of difficulties arose in 2015. One can argue, potentially, that that is a continuation of similar problems. But that is a very context-specific finding, and one which, with respect, only the RSDO can make. It is a difficult one. I should note, take the Palestinian example. We talk about how Gazans have a fresh claim after 23 October 2023, and in many ways they would, because something horrific, a genocide, occurred after that. But it wasn't as though persons in Gaza were having a very good time before that. So one must distinguish between the nuances of a claim. A Gazan could have had a claim prior to 7 October 2023, and then a substantially different one, even though he would have had a claim under both periods of time. But these debates with respect, those are debates one must have on the facts of an individual case, with proper up-to-date evidence, with the inquisitorial approach of the RSDO. Here we don't even have affidavits that I think are more than 4 or 5 years old. So those questions are simply not before this court.
Thank you, Mr. Simmons.
Mr. Simmons, just help me here. Is this case about the merits or not of your applicants?
We would submit. If by merits you mean, are my clients, should they be given refugee status? That question is not before this court.
So we don't have those facts before us.
You don't have those facts before that. We don't actually really know what's going on in Burundi. While there's a dispute between the parties, all of our affidavits were those filed in the High Court, which was now some time ago. We have no evidence on what the situation is.
None of the parties ever interrogated or debated the merits of the applicant's claim.
It was raised by the respondents as a point taken in the lower courts with respect. It doesn't seem to be raised today, and correctly so. It may well be that the sheer elapsing of time will have undermined my client's claim to refugee status. Perhaps Burundi has gotten better. We do not know.
Sorry, for the proper determination of this case, would it be permissible for us to venture into the merits of the case?
I would submit not, Justice Machopo. With respect, we simply don't have the facts.
We don't
have the facts, and the decision on how to interrogate those facts lies with the RSDO. That was one of the findings of this court in Ruta. It said it's for the RSDO to interrogate these factors. Because let's suppose even if we did have affidavits that were not many years old, this is not an appropriate forum for the interrogation of a particular person's circumstances. They should be there. One should ask them questions. There are protections such as confidentiality, such as interpreters. One needs to be able to sit down with them and say, what happened to you? These are my concerns. That is not a role for this court. The court's role, if ever, will be that of a review court. It is not a decision-making body on the merits of any refugee claim.
Okay. The submission was made by your colleague that once the application has been refused, the applicants must go back to their home country and apply. I'm testing this in light of what my brother Rogers and my sister Chikri debated with you on the position of the department and on what Justice Chikri put to you, that if the application is refused, following the jurisprudence of this court, can the applicants say, no, we are now expressing an intention to stay or not stay? On the submission made by your colleague, he says once it is done, they must go back. Is that point available to them or not?
Let me check that I understand your question.
Let me put it back. On the formulation put forward, or the proposition put forward to you by my brother Rogers, was that what is it that the department did or did not do? You've canvassed that point. On what my sister Chikri put to you, that if it's refused and they are arrested, they may raise the point that in terms of the jurisprudence, we are entitled to be taken somewhere to those offices to go and reapply. Right? On the submission put by Mr. Ramokhale, is that on behalf of the department, say, once there is a refusal, they have to go back. I hope I understood him correctly. One, the department is lax. Two, my colleague says, anytime they are arrested, they will raise the point to say, we've got new facts, please take us to the relevant offices to raise new facts. The submission from the department says, once you are rejected, go home.
Yeah.
I've raised three possibilities to you.
Are you asking which is correct?
Yes. I want your comment on those three possibilities. The first possibility by my brother Rogers, I have no problem with. You've canvassed it extensively.
Okay, then.
More interested with what Justice Chikri and Mr. Ramokhale may have put to you.
With respect to my learned colleague's submissions, perhaps unsurprisingly, I disagree with his client's approach. His approach is that there are no reapplications, and for the reasons you've heard at length from me, we submit that you can. So that entire closing of the door is an impermissible and unlawful attitude.
But would that be the same answer that you would give to Justice Chikri to say, once there is that, the door is closed?
No, the door is closed on the debate I had with Justice Chikri, if I understood her questions correctly. What would happen if my clients tried to reapply is that they would then get to reapply. Something they've never had in all of these years. They would be able to go before an RSDO and they'd be able to say, this is what has changed. If they fail to show something has changed, then they are found to be abusive and then then it process.
Okay.
If they succeed, then they are back into the procedure as normal and they get the rights and protections of asylum seekers and eventually refugees.
Okay, thanks for the clarification.
Sorry, Mr. Simons, just one aspect so that it doesn't get lost in the very interesting debate we're having. I understand the department's position, not that a right to reapply can ever exist. Their position is that within the framework of the Refugees Act, in its current form, that right doesn't reside there. That's as far as they go, not so. They're not saying that as a matter of policy and as a matter of law, an amendment to the Act, for example, cannot create such a right.
That's my understanding.
That you understand? Okay, thank you.
Thank you, Mr. Simmons.
Thank you, Deputy Chief Justice.
Go ahead, Mr. Ramokhale.
Thank you, Deputy Chief Justice. I'll try to speed through and uphold members of the court from their lunch. We will make in reply 4 brief submissions. The first is to recognize the important concession by my learned friends which is that there is no express provision either in the Act or even in international law instruments and conventions that allow for a right to reapplication, that the only way that the court could actually get there is to support the interpretation that they advance. The second is that, and this seemed to have been, to preoccupy the debate quite a lot, about the abuse of application provisions in the Act. And the argument, as I understand it, is, well, because the definition section contemplates one or more prior applications, it follows as a matter of law that the Act contemplates more than one application. And the answer, as I understand it, was, well, because Section 24.3b empowers an RSDO to consider an application, they could very well reject the application. Now, if I could ask the court to go, I'm not sure if the members of the court have a copy of the Refugee Act, but if I could begin at Section 21 of the Act. It provides in Section 21A that upon reporting to the Refugee Reception Office within 5 days of entering into the Republic, an asylum seeker must be assisted by an officer to receive applications. And then it says an application must be made in the prescribed form, and then it sets out the process. In 22 of the Act, it provides that an asylum seeker whose application, in terms of Section 21.1, has not been adjudicated, is entitled to be issued with an asylum seeker visa in the prescribed form, allowing the person to sojourn in the Republic temporarily, subject to the conditions as may be imposed, which are not in conflict with the Constitution or international law. So to the debate that Justice Chikwe was having with my learned friend, it is simply not a mere application. It's an on-application on a reading of Section 21.1 and 22.1, you are entitled as of right to an asylum seeker's application. So, Justice Matopo, to your question earlier about what would become of the three scenarios, if a person had gone through the process, the application was finally determined and rejected, Section 24.5 says they ought to be treated as a illegal immigrant, and I'll come to Section 24.5. But what would happen in that particular scenario is, on merely evincing an intention to reapply, the whole process will begin again. And so it's not a mere application to be considered, it's an application that attracts rights, the right to sojourn, the right to work, and all the rights that are attached to a visa under Section 22. So it's simply not true, with respect to my learned friend, that there's a discretion on the department to not issue an asylum seeker's visa. They are mandated, certainly on this decision, on this court's decision rather, in RUTA, to give you a visa as of right. And they have to go through the process, the whole process of an RSDO interviewing you, the appeal process, the review process, and if that is rejected, you simply come back into the queue again, because there is no buffer on the current structure of the Act to stop those kinds of applications. Now, the right that my learned friend seems to be arguing for, which is, well, the stopgap measure, what stops the abuse, is Section 24.3, which is the power of the RSDO to stop abusive applications. If the court could go there, in Section 24.3, it provides that the Refugee Status Determination Officer must, at the conclusion of the hearing, conducted in the prescribed manner and subject to the monitoring and supervision in the case of paragraphs A and B, subject to review in the case of paragraph B by any member of the Standing Committee, and then it says in B, reject the application as being manifestly unfounded, abusive, or fraudulent. And so when you read the definition of an abusive application in Section 1, together with the powers of the RSDO in Section 24B, it is a power to reject an application. It is not a power to reapply. And so one can't rely on the definition of abusive application as entitling a second or third application. What it tells a RSDO is to reject the application, not want to actually subject a asylum seeker to the entire process. So, Justice Savage, to your question about whether an appeal or review process allows for a process of new facts, I think it's readily accepted now that there's a potential actually or possibility of including new facts in that particular process. But I do have to emphasize that it's not a meaningless application. It's not a mere right to be considered. It's a right that attracts to it, different to an application brought before a high court. Rights and entitlements because of the provisions in Section 22.1 which is to sojourn in the country, in the Republic rather, temporarily, the right to work, the right to access social benefits. And so, yes, the department is concerned about what that abuse might mean, because a mere evincing of an intention to reapply, if this court were to accept the version of the respondents, would simply restart the process again, because, as Justice Colopin put, there is no mechanism similar to those international law instruments, similar to those instruments from foreign countries, that distinguishes between the two. If I could then, there was a debate that my learned friend had about what the basis of the rejection is. And Justice Matopa, you had asked whether they had been subjected to a process. If I could ask the court to go to the core bundle 1. I've taken the court to page 56 of that bundle that sets out what I had submitted earlier as the basis of the litigation, particularly that paragraph 5 about the gap. What the court then has from pages 44 down to page 55 of the core bundle is the email correspondence exchange between the UCT Law Clinic and the department. The important part is this. At page 46, after a culmination of lots of emails between the two, the UCT Clinic says that, dear Mr. Mudimisa, we hope this email finds you well and thank you again for your attention to this matter. As per your instructions, all 3 of the Burundi women have now been interviewed by Ms. Kilembe at the Cape Town ROO. For ease of reference, I attach both our affidavits as well as those completed by Ms. Kilembe. Then, what then the court sees is after the interviews at the Cape Town ROO is the email the court sees that has been spoken about a lot on page 45, where Mr. Mudimisa says, a failed asylum application who has not departed the Republic after he or she has been rejected. A failed asylum applicant who has not departed the Republic after he or she was rejected must be deported. That's my instruction to the officials, and I'm awaiting a further update. And then he says, those who return from their countries and wish to apply, they are free to apply at any office. He explains the context of this particular email. So in short, Justice Matopa, they were interviewed. Their applications were received, the letter was received, and they were interviewed. He then explains in his answering affidavit the context of this particular email exchange. And that begins in the same bundle, core bundle 1, CB 78, at paragraphs 18 down to 27, which is on page 81. And Mr. Mudimisa says, between the 3rd of August and the 25th, various email exchanges were exchanged. It is apparent that I requested the applicants to be interviewed at the Cape Town reception office. On the 2nd of October, after the interviews, the applicants' legal representatives wrote to me inquiring what the next steps would be. By then, it became clear that the applicants' previous application for asylum had been rejected and that they remained in the Republic illegally since their applications were rejected. In keeping with the stages of envisaged by the provisions of the Act, I replied to the applicants' legal representatives, informing them that ordinarily failed asylum seekers must be deported if they fail to comply with the department's notice to depart. As already stated above, the applicants were given the same notice and they had not departed. However, at that stage, I had not received a report from the relevant official regarding the outcome of the interviews conducted with the applicants. I conveyed this to the applicants' representatives. At no stage, no decision regarding the applicants' request to apply for asylum second time, purportedly on the basis that they were surplus refugees, had been taken. So in short, they went through an interview. And he says, because of this particular difficulty, and he goes on to explain it further, particularly paragraphs 24 and 25, where he says, moreover, when the asylum process is completed and failed asylum seekers do not depart from the Republic as they are required to, the Act does not contemplate that they may apply for asylum again. On the contrary, their continued presence in the Republic until their departure is regulated by the provisions of the Immigration Act. Put differently, the Act does not contemplate that a failed asylum seeker can benefit from the asylum process a second time. And then, if I could commend again paragraph 26 on the next page, 81, that sets out again the department's position, that one, the Act does not contemplate Those whose applications have been lawfully refused and who remain in the Republic can apply more than once, and because this will result in an abuse of the process. So there was some process, Justice Matopo, but the department's position was legally they're not entitled to entertain the second application. Deputy Chief Justice, I do have one more submission, but I'm out of time.
Well, I think you and your colleague today have demonstrated you have no regard for that bill.
I apologize. I apologize indeed.
Questions? Well, make that submission. There are no questions for you.
Thank you. So, in short, what we say is that this was the process that was followed by the department. Justice Rogers, there is simply no evidence about what the cause of the difficulties was with deporting the respondents. As I understand the position of the department, and I think, as a court will know, there were initially 3 applicants in this matter. A second of those 3 has not been located, and the High Court struck the application from the roll as a result of that. But the difficulties about immigration and the concerns regarding the floodgates is not one that's of the department's own imagination or making. In fact, if the court goes to...
Mr. Ramakhala, you were making one submission.
I will then stop there. I was just going to direct the court to paragraph 58 of Ruta.
Thank you. Thank you very much, Mr. Ramakhala.
Thank you, Deputy Chief Justice. If there are no questions from the members of the court, those are our submissions.
Yes. Judgment is reserved. Court adjourns.